Hello, everybody. Hopefully. Maybe. Hello, everybody. Hopefully. Maybe. Okay, looks like we're live. Hello, everybody. Hopefully. Maybe. Okay, looks like we're live. Hello, everybody. Maybe. Make sure I can see it on my end. Yeah, that looks right. 7 watching. Okay, cool. Hey, Trey. Ooh, I'm sure. So for Christmas, hold on, let me make my camera bigger. This is how I found out that my family knows that I have a YouTube channel. Is I got a Tumblr with my name on it. So that was exciting. Hey, Wipey. Ooh, I need to put new on. There we go. It felt accurate. I should say, so the first case, the one with Kyle, where Kyle takes the belt out case. Ooh, I'm going to sneeze. Can I find the mute button in time? I did, and now I don't need to. Okay. Hello, Marjorie. Thanks for joining. Make sure you tell Marjorie to hit the subscribe button with her little... So the first case, this Kyle Winchester case, where he takes the belt up. One of the reasons I found it interesting is what he's defending against is me getting monetized. It's a child abuse conviction. And what you're going to see as the case goes along, just keep an open mind. That's all I'm saying. It's an interesting case, and see whether by the end you think there even was any child abuse. Everything I just said sounds terrible. I know that. But just bear with me and give it a listen, and I think you'll see what I mean. Yeah, it's this is a serious one, and the second is a serious one, but the third one, the disbarment case, is just a lawyer getting punished. So, I mean, that's going to be a palate cleanser. The judge on the left, Amanda Mercier, she's the chief judge of the Court of Appeals. In the middle, this is Stephen Dillard, or Judge Dillard on Twitter. He is the, I think, presiding judge or something like that. He's the second guy, I guess. And then this is Judge Land, who you can't see, but over here to the right, I'll have to adjust that. He is now on the Supreme Court. So this is from earlier this year, but Judge Land is on the Supreme Court now. So these are three very high and mighty lawyers, or judges, I guess. Okay, I didn't check the sound on this. Hopefully you can hear this.
Good morning, Madam Chief Judge, Your Honors. Thank you for having me this morning.
I can't hear it.
My name is Kyle Winchester, and I have the privilege of
this...
representing Justin Wilhelm.
I have my earbuds in so I can listen to my phone, not my headphones from my computer so I can hear the computer. That's an important thing. You need to have the right headphones on. I'm smart, you know. I swear. Okay, let's go.
Jonker, the appellant in this action. This is a conviction for one count of cruelty to children in the first degree, Superior Court of Forsyth County, and we've raised 3 enumerations of error. The first presents what I see as a compelling question of whether this crime was proven at all. The second is an issue concerning the co-defendant who had resolved her case's invocation of the privilege against self-incrimination when Mr. Jonker tried to call her as a defense witness. And the third considers ineffective assistance of counsel for the failure to request and object to several contemplated jury instructions, and specifically a lesser included offense that applied during the case. In the summer of 2017, Justin and his wife, Louisa Jonker, had triplets after struggling with fertility issues. The child at issue, Bentley, was born premature. And at 8 weeks, he suffered a subdural hematoma and was rushed by Mr. Jonker to several medical providers. The first was a urgent care doctor at about 5:30 p.m. that evening, who reported that everything was fine, did not observe any bruises to the legs. And then later that evening, he started the twitching, the convulsing that was reported again, and then Mr. Jonker rushed Bentley to the emergency care unit at Children's Hospital of Atlanta.
Yeah, like I said, just bear with me. He's going to run through the facts, but once we get like halfway through, or maybe like 5 or 10 minutes in, I think you'll see.
The case started with 9 counts, and the jury and most of the disputed issues in the case concerned what was the cause of the subdural hematoma and when it was caused. The jury, because most of those issues, a lot of the medical problems involved the other counts, the injuries to Bentley's legs was not focused on or developed as much as some of the other counts. The jury acquitted Mr. Jonker of counts 1 through 8, but convicted on count 9, and so the appeal is primarily about the cause of the leg injuries and whether it was proven that not only that Mr. Jonker caused those red marks, but that he did so with malice.
Other than this specific incident involving the legs, is there anything in the record that shows that there was any history of neglect of this child by your client?
No, Your Honor.
Okay.
No. Concerning the legs, the state primarily relied on Mr. Jonker's statement, State's Exhibit 26. In that statement, it's about a 45, 50-minute interview where Mr. Jonker recounts the events of...
9 was... Let me see, I want to get the exact wording right. Here it is. It is... Let me see, cruelty to children in the first degree.
September 7th.
This is where he's the child's in the crib, and he's trying to. Is that the one you're referring to?
Correct. So his statement is that after feeding him a 4-ounce bottle of formula, the child starts vomiting, having explosive diarrhea, and is arching his back as he's struggling to breathe. Jonker moves him to the pack-and-play table, and during that period, there's a question about whether he causes the injuries.
Right.
I think there's a very interesting proximate cause defense here because those leg marks were not seen by the urgent care doctor 5 hours later when he was first taken to the medical provider. And then, as the brief sets out, the hospital photos of the legs that are taken 10 to 11 hours after this morning transaction show what I would argue are fresh marks on the legs, not delayed or healing bruises as the doctors distinguished with some of the fractures they observed. But
the conviction is based solely on the marks on the leg, right? That's what he got. That's what he got 15 years for.
Yes, Your Honor. The indictment alleges that he caused the red marks by pressing on Bentley's legs with his hands.
So, he doesn't deny that, though, correct? I mean, he basically says, look, I was trying, I mean, I'm paraphrasing, but he was basically saying, look, my child is vomiting, convulsing. I'm basically trying to save him, and I maybe held him down too hard, trying to keep him from arching off while he's either having a seizure or what's happening. I find that concerning because you could do a lot of things. Like if your child's walking out in front of a car and you reach and grab their arm to stop them from walking out and grab, in front of a car and you accidentally bruise their arm, are you now guilty of a crime because you grabbed your child too hard by pulling them back in? Or what if they're about to walk off a cliff because they're looking at their phone and you pull them back in and they bruise that?
One moment of levity is I feel like Judge Mercier has kids based on that specific example.
That way, or maybe they choke on something and they have a Heimlich maneuver and you bruise your rib. I'm having a really hard time in this particular case figuring out how this conviction stands on the evidence that was presented. Let's talk about the jury charges specifically, or the lack thereof, on the lesser includeds. It seems to me that there was a discussion that those lesser includeds should have been requested. Like that was always the intent, but that did not happen. Is that correct?
Correct. That's the record that we developed at the motion for new trial. Trial counsel testified unequivocally that reckless conduct as a lesser included was discussed with Mr. Jonker, and there was an email admitted from trial counsel's file that he intended to send to his client in the recess between the evening on the third day of trial and the beginning on the fourth day, advising him that we should request this. And the intent was exactly what ultimately happened, which is that if the jury found that his admissions to holding the legs on the changing table caused the red marks, the jury would then be presented with the question of criminal intent. Was this a negligently caused injury that would result in misdemeanor punishment, or was it maliciously and wantonly inflicted, which causes the felony conviction and the 15-year sentence?
What evidence is there in the record, if any, and this is probably an unfair question to ask you, and I should save it for the state, but I'm going to ask you anyway, what evidence is...
Okay, Aaron says, hey, Jim and friends, hope you had a good holiday and that Santa treated Jim's dog. My dog got more presents than I did. I'm not even kidding. That's just that. My parents got my dog more presents than they got me.
In the record of malicious intent, other than his own statement just saying, I was trying to stop my kid from convulsing and falling off the table, what other evidence would suggest in any way there was malicious intent that he intended to actually harm this child?
My answer is none. The evidence that's been cited in response from the state is the testimony of Dr. Bleekrode, which was the first pediatrician that he saw in the emergent care, but that was not a specific expert opinion that this wound was inflicted maliciously. It was rather a general statement that a child of this development could not resist an adult male trying to hold it down. But, and I noted this in the reply brief, I think this is page 3 of the reply brief, contextually examined, the testimony of Dr. Bleekrode was not that Mr. Jonker's account was impossible. It was that a child could not resist an adult male holding it down, but it could squirm and wiggle, which is exactly what Mr. Jonker conveys to the investigator several times in the recorded interview.
Wasn't there testimony that from at least one of the doctors or one of the medical professionals?
Oh, I should add, so Judge Dillard in the center here, he's the one in Georgia, and this is before he was the presiding judge of the Court of Appeals. He was the one that led the charge to get all Court of Appeals hearings on video. So it's thanks to him that we actually have this video. He's the one that led that. He's big on transparency. And so he gets all the credit in the world for that. And as a few years later, the Supreme Court followed his lead and put all of their hearings also on video and live stream all their stuff. So thanks to Judge Dillard for that.
Professionals that his demeanor at the time, that he's the one that brought the child to the hospital, and that by all accounts they viewed him as a caring father?
Correct, Your Honor. That was Dr. Bryant. And yes, it is Mr. Jonker that is caring for the child while Ms. Jonker is at a psychiatrist's appointment. That's when this first event occurs. Then it is Mr. Jonker again taking Bentley to the urgent care appointment where they see Dr. Patino, and Dr. Patino notes nothing wrong, no abnormalities. And then it is again a third time Mr. Jonker taking Bentley to the emergency room 10 hours later in the evening when he begins to have these episodes
Did
a third
I
time.
read in the record that they videoed one of the episodes as well?
Correct. That's State's Exhibit 28.
So just to reiterate what he just said there, the father took the baby to 3 different doctors over the course of this day when this baby's health was declining. So 3 times over the course of the day, and the injury in question supposedly relates, well, it did relate to the father holding the baby while it was convulsing to try to keep it from falling or moving around and hurting himself. So that's where we are. It's a father tried to keep the baby from hurting itself and took it to a doctor 3 different times over the course of the day. I believe it was over like 10 hours. So that's the state's theory too. That's not just the defense lawyer saying this. That's the state's theory of the case. And the doctors all said it seemed like the father was just trying to take care of the child, that he was a loving, caring father taking care of the child. And the father's not a doctor, so he has a baby that's clearly in distress, not qualified to, give any kind of medical treatment. So he's kind of helpless here, which is kind of, I assume, a parent's worst nightmare.
That was Mr. Jonker's cell phone video of what Bentley looked like when he was manifesting the twitching that Jonker talks about in the interview with the investigators. And that's available in the record, the cell phone video, State's Exhibit 28. But on the malice question, I think this circles back to Judge Mercier's first question about sufficiency of the evidence. The case that I think bears very, very strongly on enumeration 1 is the Bruton decision from the Supreme Court in 1996. In Bruton, the Supreme Court block quotes some language from Justice Sears talking about that evidence of malice has to rebut acts done in pursuit of a justifiable parental function, and that is what was not shown here.
That's lawyers speak for parenting as Amber just said, parenting is terrifying. The parents doing their best to help their child with something that they're just not qualified to do. You need to have evidence of malice showing actual malice. Parenting is hard.
Difference between acquiescing to an investigator's theory of how these marks were caused and proving that they were caused maliciously. Even the state's theory of how these red marks occurred was not that he did it maliciously. It was that he, during an emergent circumstances, applied too much pressure, which could be criminally negligent if you take that view of it, or it could be an accident done in pursuit of the safety of your child.
Look at their faces. I think this is normally when you're talking and the judges look like this, it is bad. But I think in this case, it is good for Kyle. They are not thrilled with what they're hearing.
Child. Under either circumstance, malice was not proven.
So that goes back to the ineffective claim on the...
And again, think about what he just said. It is not the state's theory that he was trying to hurt his child. The state's theory is that he grabbed him too hard while he was convulsing. So it's not even the state's theory of the case that he was like trying to hurt his kid during these circumstances.
On the lesser includeds as well, because obviously, if those had, from what I have read thus far, if those lesser includeds had been properly put before the jury, we might have had a very different outcome based on the evidence or the lack thereof that I see in this case.
Your Honor, I personally agree completely. This.
Oh man, that was funny. She basically stated his theory. She said, "Yep, you got it, Judge."
First discussion of a lesser included offense occurs during the motion for a directed verdict. In response to the trial court's comment about letting count 9 go to the jury, trial counsel closes the motion by saying it's insufficient to show malice, but it could support battery or a lesser included offense, but not malice. And so...
Did the trial counsel give any...
I love Judge Land's accent. He's my favorite Supreme Court justice just because of his accent. That's not true. It's Pinson, but he's top 3.
Offense, but not malice. And so...
Did the trial counsel give any reason as to why they didn't request the lesser included?
I think his statement was that this was... Count 9 was not the primary focus of the defense in this trial because there was so much medical testimony about the cause of the subdural hematoma and when it happened. And I think his testimony was that this was kind of lost in the moving parts that can occur during a trial, and it was an oversight, not an intentional.
He dropped the ball.
Yeah. I don't.
Kyle was trying so hard not to say that.
Counsel, and if y'all have questions, it's on. You didn't ask to reserve.
Yeah, my favorite Supreme Court judge, actually both of the redheads would be my top 2. And then probably Land, because the accent would be number 3.
Anytime, I don't think. But if I can make a recommendation, I don't want to cut you off. I would reserve the rest of your time, and I think we've got some questions for the state.
Thank you, Your Honor. I'll do so.
I've never heard that before. That has to feel so good. Oh, man. I don't know if any of you have ever heard something like that, but this is why my tweet about this talked about Kyle going belt to ass, because
But if I can make a recommendation, I don't want to cut Astor's off.
He dropped the ball.
Yeah. I don't, Council,
I know.
if y'all have questions, it's not.
I got to get rid of these blinds. I'm going to switch my desk around at some point.
You didn't ask to reserve any time, I don't think, but if I can make a recommendation, I don't want to cut you off. I would reserve the rest of your time, and I think we've got some questions for this day.
Thank you, Your Honor. I'll do so.
Look at how land is sitting. Oh, man. So just to reiterate, what we have here is a father of a premature baby saw his child convulsing, grabbed its legs. The state, everyone agrees that he wasn't trying to hurt the child. Took the child to the doctor 3 different times over the course of the day, and then is charged with cruelty to children in the first degree. Gets 15 years, even though his child had just passed away. And as of this hearing, was sitting in prison. And he was acquitted on the first 8 of the 9 charges.
Good morning, Your Honors. May it please the Court, my name is Tom Sider. I'm an Assistant District Attorney with the Belfast Judicial Circuit. I represent the state in this matter. First of all, I would submit, Your Honors, that there was, in fact, ample evidence, sufficient evidence to prove the charge that he was convicted of in count 9. For the simple reason that Mr. Yonker himself, the uncontroverted evidence was that on the 6th of September of 2017, Mr. Yonker was the only person in that home with not only Bentley, the victim in count 9, but the 3 other children as well.
Right.
As Ms. Yonker went to her...
So he's also he's watching 4 children by himself when this is happening. I mean I wouldn't know what to do in that scenario.
Psychiatric appointment or mental health appointment at 10:20. He testified that at 10:30 he was feeding Bentley, as he was feeding Bentley, an 8-week-old child who was prematurely born, an immobile child. As he was feeding Bentley, Bentley began to projectile vomit and had explosive diarrhea. And during the course of that incident, he began to gasp for air, arch his back, and attempted to throw himself off of the changing table. Now, Your Honors, based on Dr. Bleakrode's testimony, at that age, a child is not able to roll over, a child is not able to hurl themselves off a
But they're
changing
talking about
table.
in the ordinary set of circumstances. They're not talking about if a child is having a seizure or throwing up, virtually aspirating on a table. I mean, I agree that a child that small can't do that, but did he specifically say that's not possible if this child is aspirating, vomiting through his nose, his mouth, and having explosive diarrhea? Did he specifically touch on that point, or just children of that age can't do that?
No, Your Honor, Dr. Bleakrode did not testify as to that particular point. But I will say that Dr. Bleakrode was their pediatrician for a long time, so she knew Bentley personally.
Right, but there's a difference between testifying what a normal child would do under normal circumstances versus a child that's going through that medical complication. And that testimony supports clearly that under normal circumstances that's not going to happen. But I'm just inquiring as to whether or not she testified if these facts were happening, there's no way this child could have fallen off that.
No, she did not specifically testify to that, Your Honor.
All right, thank you.
But regardless of that, I mean, Bentley simply didn't have the muscular control to be able to try to hurl himself off of that changing table, whether he was aspirating or gasping for air or not. And the state would submit, Your Honor, that there were other avenues. Mr. Yonker, during the course of his interview, which is State's Exhibit 26.
And again, so after the incident, the father, what's his name, Justin Jonker, was all the name. He spoke with the police, and he gave an interview. He wasn't trying to hide anything. He wasn't defensive. Talked to the doctors, talked to the police. He talked to everybody. That's all the evidence they have is basically the statements that he made to the police voluntarily. Yeah, exactly. He's not exactly. I couldn't say it better. He's not in control while he's having a seizure. I mean, a seizure is involuntary muscular contractions, as far as I'm aware, or at least that's a part of it. So it's not like he, was voluntarily moving. But Mercier's question definitely got
In the record, just says time and time again and demonstrates how he grabbed Bentley's legs.
Right.
And at one point, I believe it's about 15 minutes into the video, he actually says, and that's when I squeezed his calves harder than I should have.
Does that sound like a guilty person, though, or does that sound like a father that...
Watch this face on the left here.
Than I should have.
Does that sound like a guilty person, though, or does that sound like a father that's feeling remorse over what happened? You know, I mean, I don't know, counsel. I'm just going to tell you, this case troubles me greatly. Can you point to anything in the record? Let's assume for the sake of argument that he was negligent in how he handled the child.
I'm sorry, I want to listen to that again. That was like appellate lawyer crack.
Harder than I should have.
Does that sound like a guilty person, though, or does that sound like a father that's feeling remorse over what happened? You know, I mean, I don't know, counsel. I'm just going to tell you, this case troubles me greatly. Can you point to anything in the record? Let's assume for the sake of argument that he was...
I'm sorry, I love Mercier. I just discovered her recently. Just look at the way she drinks this water.
To anything... This case troubles me.
That's an
greatly.
angry drink of water.
Can you point to anything in the record? Let's assume for the sake of argument that he was negligent in how he handled the child. Is there anything in the record to suggest that this father intended to hurt the child?
Well, Your Honor, that goes to the issue of malice.
Right.
And if I may...
Yeah, absolutely.
Okay, this is one thing. Notice the question he asked. Is there anything about malice in this case? Can you point to anything in the record? That's the question.
This court dealt with that very issue in the case of Flakes versus the state,
I was
which
going
is
to case law.
365,
Not
Georgia
answering the
Appeals 97, at page 99. That's a 2022 case that I believe Judge Mercier and Judge Dillard, you were involved in. In that case, the court said, for the purposes of the child cruelty statute, 16570, malice implies the absence of all elements of justification or excuse in the presence of an actual intent to cause the particular harm produced, or the wanton
Yeah, but that's...
and willful doing of an act with an awareness of a plain and strong likelihood that such harm may result.
I do not see under the facts of this case how it fits in either one of those. I think that's the problem.
Well,
Because
Yeah, what evidence is there? I'm assuming you're traveling under the second.
it's a wanton and willful doing of an
Right,
act.
so, I mean, what in the record demonstrates that this was a wanton and willful act as opposed to, just simply a negligent act?
Well, the fact that Bentley was an immobile child, 8 weeks old, and Mr. Yonker is a very large individual, as you
What's
can
that
tell
have to do with anything?
from his interview video.
Right.
And when any adult grabs
Who took the child to the hospital?
Mr. Yonker did.
Okay. And wasn't there testimony that, I mean, I guess from the record at least, it seems like at every turn, this is a concerned father. Now, maybe he was overwhelmed in the moment, maybe he grabbed the child, and that's the other thing, like, he admits to all of that. Like, I mean, you point to that as evidence of it, but to me that sounds like evidence of a father that is distraught over what's going on with their child.
Well, interestingly, and the court brought up the video of Bentley having a seizure, rather than immediately taking the
I hate this part so much. I watched this last night. This is the part that, well, one of the parts that maybe you want to cover this this argument. I hate this part.
The court brought up the video of Bentley having a seizure. Rather than immediately taking the child to get medical attention when Bentley was having the seizure, Mr. Yonker grabbed his cell phone and videotaped a 52-minute seizure, or 52-second seizure that Bentley was, having.
I can think of a lot of reasons a good parent would do that quickly, is to be able to show the medical professional what was going on. What did he say? What does the record suggest? Was he asked about the video and why he did it?
I believe that's what he said. He wanted to show
Yeah.
the doctor
Yeah.
what was happening.
I mean, does none of this strike you as odd? I mean, he was charged with 9 counts He's doing 15 years in prison?
And let me ask this, it's not entirely correct, because correct me if I'm wrong, the mother was there early in the morning and she left. Now, the sickness occurred after she left, but if in typical cruelty to children cases, if there's an issue with like a subdural hematoma or something like that could cause that vomiting and that type of reaction, she was in fact there in the morning before she went to her doctor's appointment with him and the children, correct?
She was.
And so now we come to her Fifth Amendment when she pled guilty to one count. The other cases are null prost and she's not, they prohibit her from testifying. Tell me why that's okay.
Well, first of all, because Ms. Yonker was
Okay. He's going to explain it.
charged in the indictment, although she pled guilty to count 4, the other counts were null prost against her. At the time she entered her plea, which was December 5th of 2022, 1733 extends the statute of limitations beyond that point 6 months and gives the state an opportunity. If Ms. Yonker, for example, if Ms. Yonker were to take the stand and make incriminating statements, the state could have come back and re-indicted her within the 6-month period.
Okay, so basically, both the parents were charged on the same indictment. The mom pled guilty, but there were other things for which she could have been charged, for which she was charged. And even though she had already pled guilty, she still pled the Fifth and would not testify at the trial against the father. And the defense wanted to call the mom, but again, she took the Fifth and didn't testify. So that's what this enumeration of error relates to.
Of time through
So if
March
this
of
case goes back,
2023.
if we reverse this case and it goes back, that 6-month limitation is gone and then she would be required to testify, correct?
I would imagine at this point it would.
What about what is your view on the lesser included, not including that with count 9?
And before you answer that, I want you to tell me about exactly what he said about maybe I held him, the child, harder than I should have.
Well, yeah.
This notion of I did something harder or different than I should have, why is that not negligence? And why does that not support the lesser included?
That's basically like definitionally, if anything, negligence. Doing something other than what I should have by mistake. That's pretty much textbook. Because why would the DA even investigate this? I don't know. I think there was some evidence. Let me see. Count 4. Let me see if I can find that actually. Yeah, actually, I don't know. I think the child had some injuries other than this one. But again, the child was also born very prematurely and had some, I believe, some congenital injuries. So I'm not even sure if the child was injured by the parents at all. But again, I don't have the full record.
Well, it may very well. I mean, again, intent is a question for the jury, which this court also said in Flakes. Intent to cause a particular harm is particularly a question for the jury. And
So why don't you get a lesser included if there's evidence in the record that maybe he held the child harder than he should have? Why is that not a classic reckless conduct lesser included?
Well, and the decision of whether to request a jury charge or what jury charge to request is a tactical, strategical decision made by trial counsel.
Yeah, but he actually doesn't have an explanation for why he.
Yeah, he's just okay. So with respect to ineffective assistance, if the ineffective assistance is basically because you're it's a tactical, strategic decision that doesn't pan out, that's not ineffective assistance, and that's kind of what he's getting at. But I see state appellate attorneys do this a lot, where they just say, "Oh, it was a tactical decision of the defense counsel," without actually explaining why it's a tactical decision.
Whether to request a jury charge or what jury charge to request is a tactical, strategical decision made by trial counsel.
Yeah, but he actually doesn't have an explanation for why he did that, and that goes back to the ineffective claim. He doesn't have an explanation for why he didn't really grant or ask for those charges, because he argued. I mean, he actually argued. It looks like he argued some of that lesser included language, but he didn't actually submit the charges or submit the jury charges. And what I'm hung up on is if he had done that, I think you would have had a very different result. Might have still been a guilty verdict, but it might have been guilty to something else. And so my question is, how is that not ineffective assistance when he even says, I don't know why I didn't do that?
Well, interestingly, Mr. Yonker was also charged in count 1 with cruelty to children in the first degree.
Right.
The charge to which he was acquitted, or which he was acquitted for.
Right.
So one would think that if the lesser included were something that the jury in fact considered.
Not necessarily, because they're hearing evidence on two different types of injuries. Maybe they believed one and not the other. But I don't think you can say just because he was acquitted on these, which were different injuries, different problems. I don't think you can equate those two things. And I think if there is a real issue of a lesser included, regardless of whether he got it acquitted on other charges, we're talking about a separate, distinct event. So I don't think those equal at all.
And there is a Georgia Supreme Court case that is directly on point with that.
Okay.
Your Honor, if I may.
Again, these are essentially it is Mama Bear. Look at Len's face. I think he's thinking the same thing I am, which is that we're asking about this specific case. We want to know the facts of this case, and every time they do that, he tries to go to case law. But he says, "I have no idea what this is about, but Georgia is notorious for charging parents with child abuse when there has been none. Georgia versus Carey and Brady Timms. I'll have to look at that." That sounds familiar.
Or at least the decisions about which jury charges to request are strategic and provide no grounds for reversal unless such tactical decisions are so patently unreasonable that no competent attorney would have chosen them. And that's Hill versus the state.
What evidence that it was strategic here?
Right. What evidence that's the next question. What evidence that it was strategic? Because he's saying it wasn't. I mean, that's what trial counsel is saying. What evidence is in the record that it was strategic, that he made that decision to go all or nothing? Because that's not what the emails suggest, because as recently as the night before the trial, they're talking about those lesser includeds.
And you can posit what the strategy would be, because we can do that. We can look hypothetically at what a strategy might be here. But I'll be honest, counsel, I'm at a loss to think of any competent counsel that what possible strategic reason there would be for not asking for lesser included here.
Well, to be quite candid with the court, he didn't give one at the motion for new trial hearing.
Can you think of a strategic reason why, were you defense counsel, you wouldn't ask for lesser
I love that question. Just put him on the spot.
included on that count?
Aside from going for an all or nothing defense, Your Honor, if he believed, as Madam Chief Judge has indicated, he sees the weakness in the evidence of the state's case, he's going for an all or nothing decision. That is a tactical and strategic decision.
It is, but there's no evidence that he made it. I think that's the problem, is that his email suggests that was going to be what they were talking about was the lesser included. He said, he doesn't give a reason why he didn't do it, but he said it wasn't strategic. That's the evidence before us. And if that's the case, and we can see that the email suggested that that's what they were going to do, I don't know how that's not a situation where we have to look at it and go, because let me tell you, this is not overwhelming evidence. We aren't even close to overwhelming evidence in this case on this charge. So I don't know how that's not a factor that we have to weigh.
It may very well be, Your Honor. And I mean, we're bound by what's contained in the record. And
yes, sir, I understand.
And I appreciate you saying that. Can you tell me, counsel, and I may have asked you this before, and if I did, I apologize, but other than let me just ask it this way. What evidence in the record, as you rightly pointed out, to you shows the intent, the criminal intent for the charge that he was convicted of?
Mr. Yonker's own statements and his own actions in the video, Your Honor. He's gritting his teeth and he's clenching his fist, showing how he grabbed Bentley's legs. Honestly, as a father, I couldn't think of any possible reason, whether my child was aspirating or not, to grab a child's legs like that. In fact,
Well, let me ask you, what if your child was about to walk off the cliff because she was looking down at her phone and not paying attention? You reach and grab her arms because you're scared to death and you bruise both of the arms terribly. Or if you're giving them the Heimlich maneuver because they're choking in front of you and you actually bruise a rib or, God forbid, break a rib, it could happen. I mean, because fear in that set of circumstances is a pretty adrenaline-inducing mechanism, I would think. And I am not suggesting that this is not something that perhaps doesn't warrant a retrial. I am just suggesting that, I'm not the fact finder, we're not the fact finder, but based on the evidence before us, it's very hard to even see how it got to that point on this charge. Now, the other charges he was acquitted on, but on this charge, that evidence to me is not sufficient. It's just not. But not with other things that are not contained in the record, particularly on the charges. That the charges are that's probably the most troubling part of this, because there is clearly a situation where a reduced charge could have made a very big difference in the verdict of this case. And it's almost like they were like, well, I guess we have to convict him of this because there were it seems very untied together without all the evidence, Mr. Sider. And I don't know how to tell you that any other way. The evidence just does not seem to support it.
Well, I appreciate the court's position. If I could just address the court's hypothetical, the difference in that case would be you have a mobile child who is in immediate danger, not an immobile child who is...
But if the child is laying there, Mr. Sider, and is aspirating, basically, and the vomit is coming out his nose and out, that is a good way to die as a child, because they are completely unable to take care or defend for themselves. A parental reaction to that... What you were describing to me, it's very difficult for me to picture a parent not freaking out and grabbing their child and going, I don't need them to have a seizure on this table.
Well, I'm sorry. At that point, Your Honor, he wasn't...
You can finish.
Yes, please go ahead.
At that point, Your Honor, he wasn't having a seizure. He was vomiting and projectile vomiting and...
Oh, well, that's much better. Definitely no reason to panic if your child is going through that.
And explosive diarrhea. As a parent, Your Honor, I mean, the first reaction when a child starts aspirating is to turn that child over. You're taught it before you leave the hospital with your baby. Turn that child over. You don't necessarily go for the legs and start shaking the legs and grabbing the legs.
One last question. The interview that you were pointing to where he makes those statements, I'm just asking for your impressions of it. In your view, in your mind, does Mr. Yonker come across as remorseful about what happened in that interview?
In all candor, yes. I mean, he does. He's not, and nobody has ever alleged that Mr. Yonker was a serial abuser of his children, Your Honor.
Right.
I mean, and in fact, counsel is absolutely correct. There was never any indication that he had abused his children prior to this, nor was there any by Mrs. Yonker.
Okay. All right. Any other questions,
No.
Chief? Judge?
Thank you very much, Your
All
Honor.
right. Thank you, counsel. We appreciate you being here today. Counsel?
So again, this isn't a situation where a guy's a serial abuser and he just got away with it this time. All the evidence indicates that he was just a loving, caring father who, he was probably in over his head, but understandably so. I certainly wouldn't know what to do in that situation.
You've got 3 minutes and 32 seconds, but you don't have to use them, but you can.
Thank you, Judge.
You have 3 minutes and 32 seconds. You can just stand up there and say nothing. You can say whatever you want. Doesn't make a difference. We've already made our mind up.
2 brief points. On the lesser included reckless conduct, the court's noted a lot about the record of trial counsel's testimony at the motion for new trial. The other piece of evidence that I'd like to note is that what he said at the motion for new trial lines up with what he actually argued during the motion for a directed verdict. So this is not a situation where you have one trial strategy and then at the motion for new trial you have a subjective statement that's different from the objective strategy pursued.
So he argued the lesser included as the directed verdict. He argued that? Is that what you're saying?
That was his position about of why there was insufficient evidence of malice.
Gotcha.
His argument to the trial judge was this could support a lesser included offense, but not the greater felony of malice.
So you think he just dropped the ball?
Correct. That's as simply as you can put it. So that deals with the included offense. Going back to the interview, I think the candid concession from the state that Mr. Jonker appears remorseful is the most telling part of why the evidence at trial did not show malice. It did not overcome the presumption of justification during a parental act, and that's exactly what they have to prove under the Bruton case.
Just briefly on the wife, or I don't know if she's still a wife, but the wife's Fifth Amendment issue where she was not deemed available to testify. What are the ramifications of that on this case? How do you think that impacted this case, basically?
Well, at the motion for new trial, we made a pretty developed offer of proof about what trial counsel intended to use her for in the defense case, and that was part of the alternative strategy was primarily he's not the proximate cause, and number two, if he did, he was handed what he called a broken egg or a problem from his wife. And there's text messages and Google searches that were admitted as part of the offer of proof to show what he intended to cross on had he been able to examine Ms. Jonker. I think the question about whether the privilege actually attached is pretty interesting. I tried to find a case in Georgia that dealt with the specific posture of pleading guilty to one count, the remaining null pros, but still within the extended statute of limitations.
Is there anything on point with regard to that?
The only thing I could find was a footnote in the Supreme Court's Elliott decision from 2019 that talks about those statements not being incriminating if the statute of limitation had expired. I think my ultimate position is in the reply brief. 1733 applies and extends when the entire indictment is dismissed, not only succinct counts, and the reason is because it has to align with Georgia's procedural double jeopardy doctrine. And I don't see how, if she admitted to one of these crimes after pleading guilty, they could bring back counts after she pled guilty to count 4, because the guilty plea to count 4 never changes. Even if there's a re-indictment for the other crimes, those crimes are still part of the same transaction, known to the prosecutor, drew the same indictment. I actually think this is a...
Let's assume the privilege against self, go ahead.
Oh, no, I was just saying, it is an interesting question, because I couldn't find
I agree.
anything that distinguished between the statute of limitations and a double jeopardy problem. Sorry, Judge Lane, go ahead.
If we were to assume the privilege against self-incrimination applied to her, does that make her unavailable?
Yes, Your Honor.
Such that the hearsay exception should be triggered?
Yes, Your Honor.
And did the trial judge reject that argument?
He did.
Okay. Thank you.
Thank you, Your Honor.
Thank you, counsel. I want to thank both of you for your briefs and for your presentations here today and for your professionalism and candor. Thank you very much.
Okay, I'm not going to go through the whole opinion, but I will just show you really quickly the result. Where are we? This one? No, not you. Sorry about that. This one? This one. Basically, following a jury trial, Jonker appeals his conviction for cruelty to children in the first degree relating to leg injuries suffered by his 2-month-old son. Specifically, Jonker contends the evidence was insufficient. The trial court erred by excluding testimony of his wife, Louisa, who invoked her Fifth Amendment privilege against self-incrimination, and that he received constitutionally ineffective assistance of counsel. Although we find the evidence was sufficient to support the verdict, we must reverse Jonker's conviction based on trial counsel's ineffective assistance. What county was this in? Was it Appling? Not Count. Forsyth County. One of the 159 counties that comprise the state of Georgia, which is the second most counties of any state in the country, behind only Texas. That's right, Georgia, that has approximately 11 million people, has 159 counties, which is more than the state of California. Still, that's totally fine. Rip this baby away from dad. Yeah. Yeah, I do think that this is one of those cases that just didn't need to be prosecuted. Again, I don't know what the story was with the mom. Maybe there's something there, because she did plead guilty, so maybe she was actually guilty. Maybe it was just to get a good deal. I don't know. In oral, I thought the judge didn't find... Yeah, I think that, because there were marks on the legs, I guess they're saying that, the jury could have found them guilty. But a lot of times the court will say they're reversing the conviction anyway. So they're they don't need to give the state something to go to the Supreme Court on. Yeah, I do think that's one of the interesting things about the states. This is particularly true in Fulton County, but I think that where the state will get into trouble will be trying to do things that they don't have to do. Like doing nothing would be the better option. They need to give one opinion and not say too much. Yeah, exactly. There's no make the decision, get the result you want as narrowly as possible. Why not? Yep. Okay. So that was the first case. Ooh, I wish I knew how to do a poll so I could ask you whether you want to do Brian Steele or the. Let's do Brian Steele. Everyone likes Brian Steele. Where are you? A25. This one. Yeah, it's funny. I usually don't do cases that are on like sensitive topics, like anything involving children, a lot of like sex crimes, because first of all, I don't want to like get. How can I put this? I don't want to get any of the lawyers in trouble if they say something that like my viewers don't like. I don't want to like implicate the other lawyers and that stuff, get them mixed up in anything. But this was a case where it just seemed like a really good example of why it's useful to look into cases that at first glance, you look at this case and it's like, oh, this guy killed his kid. And you might not want to look into it. But then when you start to dig in and look behind the facts, you realize that maybe there wasn't a crime at all. Write this one down. Let us know if they take this guy back to trial. I should do that. Honestly, I wouldn't be surprised if he just took a plea deal on something for time served. That's usually what they do. So before we switch to this next one, what was I going to say? Right, there hasn't been a decision in this case yet. Those are spicy areas. Yeah. He still has that on his record. Yeah, that's true. But that's a common thing that the state will do. Is so, let me see. I'm trying to think of a case that's a good example of this. The child was a triplet. Yep. What's a good example? A lot of times you'll have a murder case. So you have like a 20-year, somebody's done like 20 years of a life sentence. The conviction gets vacated for whatever reason. And then rather than go through it all again, the state will say, just plead guilty to, I don't know, some kind of aggravated battery, and we'll give you time served, and you can walk free, and you won't have to go through a trial. You can just go home right now. And if you don't, then you have to go through a whole another trial, and you could be convicted. And you're at least going to have to wait several more years in jail before you can go home. Yeah, I mean, I could explain this within the context of Moontook really easily, but I don't want to do that. But yeah, that's the thing that they do all the time. Just sign this piece of paper and you can go home today. You've been in prison for 20 years. You're probably going to take that deal. There's actually a John Merchant, the other Mr. Ashley Merchant. He had a case that I'm going to show soon that involved a guy who's been in prison for, I think, like 15 years. Or he's done like 10 out of 15 years. And I don't think that it applies in this case, but in that case, I could see them offering him like some kind of plea guilty or guilty plea to something that has a max sentence of like 10 years. Say, just admit you're wrong and you can go home today. And that way you can avoid any kind of Mr. Ashley Merchant. Did you look up Ryan Duke? I did. It's frustrating because there's like two guys. One is last name Duke and the other is last name Dukes. And I can't keep them separate. So, yeah, that's going to be tough for me. But yeah, I watched that last night, actually. It's funny. Ashley represents, I think it's like Ryan Duke, Bo Dukes, but then in YSL, she represented Duke, like YSL Duke, Martinez Arnold. So she had 3 Duke cases. She had cases involving 3 people named Duke or Dukes within like a month. Yep. I think that's right. Held in pretrial for 10 years, hung jury, take a plea to get time served. Yeah. I think there's another non-moot case I'm working on in Georgia where I think that's definitely a plausible outcome. You know, John Merchant, I think his name is, he's from Maine, so you know he's a good lawyer. Ryan Duke, yep. That case is wild. It seems like he definitely did it, but it was a statute of limitations thing, I think. Maine has the best lawyers and the best cats. It is known. I need to go back there, too. I need to see my parents. All right. You guys ready for Brian? I mean, half of you are just going to objectify Brian to no end. So, Matthew, I'm going to ban you. Whatever Duke it was. She had like 3 Dukes. Maybe. Oh, my goodness. Okay. You guys ready for Brian? All right. Again, this case hasn't been decided yet, so I don't have an outcome for you. But yeah, let's watch it. It's good. I really like this one.
May it please this honorable court, I am Brian Steele, and I have the honor of representing appellant. This case is from Appleton County. It's November 19th of 2019. The grand jury of Appleton County returned a 6-count indictment, 3 counts of vehicular homicide with 2 counts of DUI, 1 driving with an intoxication level above 0.08, another one with driving with intoxicants, less safe, and then hit and run was a predicate offense. There was also a 7th charge, actually, which was driving on a suspended license. The state didn't prove that. It was a directed verdict by the trial court. The jury found appellant not guilty of the vehicular homicide, 2 counts with the DUI, guilty of vehicular homicide and hit and run, and then guilty of a lesser included vehicular homicide, 2nd degree, which is misdemeanor. The sentence is 15 years to serve 8 years in prison. Appellant currently rots in the state of Georgia prison system.
He says that every single time. He always says rots in the Georgia state prison system. In like every appeal, he always says that. I tried to steal it, but I can't pull it off. But that's his go-to, is rots. I really like that.
And all that is
I tried to steal that from him.
found on record pages 12 through 16, as well as 42 through 48. The facts are pretty simple, if I could just briefly describe them to you. It's tragedy. It's Mother's Day of 2018. It's the 13th day of May. There's a gathering in an area in Appleton County. There's many people out there. The estimates were between 30 people, as many as 100 people. The deceased is there. Appellant is driving through the area. There's 1 eyewitness called from the scene by the prosecution. That person states that there's a go-kart, children going down a driveway. The deceased is a hero. Realized a car is coming, driven by appellant, got next to or in front of or the side of the go-kart, kicked the go-kart aside so it would not go into collision with the vehicle that appellant was driving, and the deceased lost footing, fell backwards. The deceased then slams along with the car, is propelled into a nearby ditch. Appellant stops the car, according to this person called by the prosecution. Appellant gets out of the car, something said to appellant. Appellant gets back in the car and drives off. Appellant put on a case, He also called someone from the scene. That person testified that the deceased caused the fatality, caused the collision. That was a transcript. It's a short transcript. 94 through 114 is the state's.
Okay, I should preface this case, I think one of the hard things to do is defend people in cases where they're clearly guilty of something, but not necessarily guilty of one of the things of which they've been convicted. It seems like the driver is definitely breaking some laws. I think Steele's argument is going to be that he didn't break all of the, he didn't do all of the crimes of which he was convicted. But clearly this is a difficult case.
Witness, and then 239 through 242 is the appellant's eyewitness. But appellant chose to testify. And appellant said that he worked, he drank a small amount of alcohol, he was going in the neighborhood of this party, of this block party. He's driving his vehicle safely. He didn't know what happened at 7:30 at night approximately, maybe a little later. Something slams into his vehicle. He pulls over. He gets out of the car. He didn't know what happened. He realizes that there's someone in the ditch who needs a lot of help, medical help. He's panicked. He runs into the ditch area. He's screaming, "Call 911, call 911." A crowd that he estimated in that moment in his time and in his life was about 100 people surrounded him. They were saying, "We're going to get you." People are pushing him. People are shoving him. He gets scared for his safety. He goes back to his vehicle. He drives home. He gets home. He tells his significant other, who testified at trial as well, that I was scared. I hit a person. We have to tell law enforcement. His significant other said they'll be here. It turned out to be his cousin, who he's close with, who was the deceased. And law enforcement about 30 minutes later came by his home. While at home, appellant was so shaken, he drank a lot of alcohol. He drank beer as well as hard alcohol, what he called shots. He was taken to the police. He did not mention anybody surrounding him. He did mention he was panicked, and that's why he left the scene, and everything else was fairly consistent. And that's a transcript, pages 198 through 219 is his testimony. His trial lawyer is a fabulous lawyer. His trial lawyer, and the prosecutor is a fabulous prosecutor. The trial lawyer argues to the jury about the hit-and-run vehicular homicide component, which is all that we're dealing with here, is that appellant was just...
So again, he's not contesting all of the conviction. He's just contesting this one count. The vehicular homicide, looks like.
...justified in leaving the scene. And the trial lawyer explained in comment, he said, common sense, you don't have to stay at the scene and get bludgeoned, you get beaten up. You can leave the scene under those circumstances. But he never asked the court, the great trial court, he never asked the honorable trial court to charge the jury under 16-3-20, 5 or 6, which is justification that does not apply to all our other justification, like justification for defensive habitation, or justification of self, or justification of others, or justification of a residence. We have a code section, just like every other state, by the way, that justification is a defense to any crime, if on the same footing as those other enumerated
And Mr.
justifications.
Steele, we're reviewing that under plain error? Is that
I raised
accurate?
ineffective.
Yeah, I think so.
So they're very similar tests, but I raised it as ineffective.
Would justification, this is what your colleague is arguing, would not have been a complete defense. So even if it had been charged, it wouldn't have completely exonerated your client under the justification affirmative defense.
Yes, totally.
Because
wrong.
he didn't call 911, he didn't seek emergency assistance, he went home, he didn't call 911. All of those things which were in the hit and run statute. Can you address that a little bit?
Yeah, that's totally wrong. So there's two parts of hit and run. It's the hit, and then there's the run. And part of the run is you have to stay on the scene and give over your license. Well, you don't give over your license if you're justified in leaving the scene. He had already called for people to call 911. 911 was already called by the eyewitness that testified by being called for the prosecution. They were already on the way. He has to render aid. He couldn't render aid because he was going to be bludgeoned, so he left. He got home and he told his wife, significant other, who testified at the trial, he immediately said, we have to call the police, and she said, they're going to come here anyway in a moment, you might as well stay here, and they're going to come to you. Juries make those decisions. Juries make those decisions on whether he was justified in leaving, and therefore it was justified in not giving over his license. He was justified in not calling the police. He was justified in not rendering aid based upon proper jury instruction. So I believe that that's totally wrong. That is a complete defense to the hit and run. If that is a complete defense to hit and run, if you do agree with that, then that is the predicate or underlying misdemeanor for.
So you could look at it as a tactical decision. His defense was accident. That was really the primary defense that he had at trial, and maybe he tactically decided not to use the justification defense. But what do we say about the prosecutor arguing arguing the issue of justification in his closing argument? How does that change the analysis for us?
I don't think it changed. I'm sorry. I feel like I cut you off.
No, it's fine. I just wonder if you could look at this tactically. If the DA had not said anything about justification, if you would have a stronger argument about the trial court charging it sua sponte, because that's another argument you make, is that even notwithstanding defense counsel not requesting it, does the fact that the DA argued it in closing make your argument stronger that the judge should have issued that charge on his own, sua sponte?
So you asked a lot of questions in that one statement. So I don't agree that there's any tactical situation here. I don't agree that accident was his sole defense. Accident's a defense to the collision. This is after the collision. This is the run. That's not an accident. He intentionally left that scene. Nobody claims that's an accident. The only defense to that is justification. That's my first part. It wasn't tactical. I asked the defense lawyer at the motion for new trial hearing, why didn't you ask for this? And he said, it was not tactical. I should have asked for it, and you know that because he argued it. The defense lawyer argued in his closing argument, and he said he was justified in leaving the scene, but he didn't get a charge on it. That's a transfer closing argument 290 through 291. It's the motion for new trial.
It's kind of like the last one we listened to, where the defense lawyer in that case also argued. I can't remember because I'm blanking. He argued something, but then didn't ask for the jury instruction. So you make the argument, but don't ask for the jury instruction. Seems like it should always be ineffective assistance.
Pages 7 through 9.
In
addition to that, sure, the judge could have charged sua sponte, but I'm raising it as ineffective. You know what the prosecutor told the jurors? The prosecutor told the jurors, even if you believe appellant felt for his safety, he had to remain under law. It's a strict liability. This is ridiculous. This is ridiculous. I can imagine me. I get into some sort of accident. I'm being threatened. Somebody tells me I'm going to kill you, and I have to sit there because this opinion in Carter versus State says no. You have to sit there. You cannot leave. And you know what the trial judge did in addition to that? It gets worse, Your Honor, Judge Davis. This is what the trial judge does. The jurors ask the question. They ask a specific question. Goes back to the accident. I just changed the deceased and appellant, but otherwise this is a quote. If the deceased accidentally fell in front of the car and it is not the fault of appellant, is it still considered vehicular homicide since the vehicle caused the deceased's death? This is in deliberating jury. It's a transcript 384 through 386. You know what the judge charged a jury for the second time in the final charge, and then in response to this instruction, the judge charged the jury that, and I quote,
Brian's got a new toy.
in any event, the driver shall, in every event, this is the quote, The driver shall, in every event, remain at the scene of the accident until fulfilling the requirements of this subsection. So I asked the court, does a justification charge need to be given? Does the state have to disprove that beyond a reasonable doubt in the face of the argument by the prosecutor, which is wrong? You don't have to stay there. And in the charge of the court that says that the driver shall, in every event, remain at the scene. That is wrong, and that's at transcript page 361, lines 7 through 10. That's the original final charge, and then 388,
Yeah,
lines
that's
9 through 12 is the second charge at the recharge. I hope I've answered all your questions.
You have. You're making two arguments about why justification should have been charged. One was the ineffective assistance. It should have been charged. The defense counsel argued it. He should have charged it. And now in addition to that, you're arguing that because of what happened with the jury question and the DA's argument about justification, there was more reason at that point for the trial judge to charge justification, especially after the jury question.
And you know what happened right after that question was answered? There's a verdict. That's what happened. I mean, this to me, I've never been a judge. This to me is so clear. If you charge that justification, he's justified to leave, the jury is asking. I know it's a jury question. I understand you can't read the minds of the jurors. They could have asked it as a whim. But they're saying, if the deceased accidentally fell into the car and it's not the fault of the appellant, is it still vehicular homicide? And the judge is saying he shall remain at the scene. That's a component to the only conviction he got. Excuse me. He was straddled with.
How do you respond to the state's assertion that under 16-320, essentially you can only have the justification defense when it's when the circumstances that are let's see.
To help someone else?
Yes, thank you.
Yeah, well that's wrong.
My handwriting's poor.
That does come from the cases cited. There's cases cited that says that's generally what it is, but that's just wrong. You can look at Harbuck, which is Harbuck versus State 280 Georgia 775. It's in Division 4, 631 Southeast 2D 351 2006. What happened there is a woman is driving with her disabled sister in the car. A police vehicle comes behind her. She doesn't realize it's a police vehicle, so she doesn't pull over, and she flees. She finally pulls over. The police officer gets out of his car, he's screaming at her, this is according to Ms. Harbuck, screaming at her and saying, roll down your window, show me your car. And she gets scared and she drives away. The Supreme Court of Georgia mentioned that the trial court charged on 16-3-20, 5 and 6. Because in her mind, she was justified in pulling away. She thought she was in danger. That has nothing to do. That is a total.
I gotta get some water. I'm going to keep this playing. Just give me 1 second.
Red herring. It does not. Look at the statute. It's a defense to any crime justification. It never says.
Go ahead, take another minute if you like, Mr. Steele, and I'll make sure and give a minute to Mr. Gephardt.
It never says. That's in case law in dicta, and it says generally. It never says it has to apply only with defending others or protecting others. That is just language. Yes, the language is there. That is a dangerous read of those cases. I believe that both issues. I separate the issues of the jury instruction for failing to charge on 16-3-20, 5 and 6, and I also the trial court did not charge. Based upon that question from the jury, did not charge on proximate cause. The answer to that question, by the way, is no. The jury's question, if the appellant did not cause that accident, the answer to the trial court, that's not a factual answer the trial court's given. It's a legal question. Under your question you're asking me, the answer is no. And you charge on probable cause. The trial judge never recharged on probable cause. I would like the court to consider these arguments. Thank you.
Thank you, Mr. Steele. Mr. Gephardt, you have 16 minutes, so we went ahead and added an extra minute to your time, sir.
Thank you, Your Honor. May it please the court, Ben Gephardt for the state appellee. Just to correct a few representations that have just been made, no witness testified that the decedent caused the accident. That's only the interpretation that was later raised by the defense. They testified to the facts and events surrounding that. Further, it's incorrect that the trial court did not charge on proximate cause following the jury's question. The trial court, and by the way, the language.
My bad. I said those are, like, calling those misrepresentations is a little strong. I mean, you can differ on opinion, but Steele said that somebody testified that as to the causation of the accident, and he's saying that, you know, nobody specifically said that. You can disagree, but that's not really a misrepresentation.
Which is that
I don't like that.
That the appellant is now complaining of that the court charged the jury in answer to that question is taken directly from the statute. So it is not error to give, and any objection would have been fruitless. Regarding also, and I would make this correction for the brief itself, and in candor to the court, this didn't occur to me until somewhat recently. I didn't really recognize its importance, but in appellant's brief, he asserts that the written charge was not given to the jury. That is not so. The trial court, as a matter of fact, found that it had in fact given the written charge of the jury directly following the jury's question that's at issue. That charge did include the pattern instruction on proximate cause. So no, the jury was actually, the trial court did answer the question and did recharge the jury on the issue of probable cause following that question. And the transcript actually says, I believe the bailiff.
I will say that I have a little bit of trouble following this guy's argument, so I'm not going to be able to give you the best breakdown.
Reply to the judge's question, the jury wants it. It referring to the written charge, and the judge answered okay. So there's some evidence on the record that yes, that's exactly what happened. The judge did give the jury the written instructions. So that issue is only preserved for clear error. Clear error has not been demonstrated since there's some evidence on the record. More so, as this issue is raised in the context of a claim of ineffective assistance, it can't rest on an ambiguous record. So I think the court must accept the fact that the complete jury charge did go out to the jury, including the pattern charge on proximate cause. So the jurors were in fact recharged on the issue of proximate cause. The judge did answer that question. So any assertion that he did not is belied by the record, and that claim fails on that basis alone. Another point that I would emphasize, and this wasn't brought up in argument, but I think it is important to Carter's argument, the case of Mondor. In that case, the Supreme Court does include the language that, for example, in hit-and-run vehicular homicide, the key question is whether the defendant's conduct approximately caused the victim's death. And that statement is problematic because it's directly at odds with the hit-and-run statute, which in 2008 was extensively revised to read out any requirement of causation, or at least the defendant now only has to cause the accident, does not need to cause the death.
Speaking of great hair, I almost picked a Joel McDermott clip, or Joel McDermott argument, but it was like a touchy subject. I didn't want to get him in trouble. But he has some great hair.
It's the accident that needs to cause the death. And I think I know the answer to that question, why those two don't mesh. That's because in Mondor, the Supreme Court cited only former law, cases deciding the law before the change in the statute. That would be citing Hoffer v. State, which was decided in 1989, and Wilson v. State from 1940. And under that division, that division discussed the admissibility of evidence, the admissibility of seatbelt evidence, whether or not the decedent was wearing a seatbelt. It was not addressing the issue of whether or not the defendant has to approximately cause the accident or the death. And that issue would not affect the holding in that division in any event. It would not affect it one way or the other. Therefore, it is simply dicta and not binding on this court or any other. So I do think that is somewhat important to Carter's argument. He has cited no other law dealing with proximate causation in vehicular homicide under hit and run, which under the words of the statute, only requires that he cause an accident, the defendant cause an accident which causes the death of another person. And I would also emphasize that neither in his brief nor at oral argument here today has the appellant demonstrated any deficient performance. He has simply argued that this charge could be asked for and should have been given. That's not the same as demonstrating deficient performance. It is true that asking for,
I mean, he did argue that the defense attorney argued a specific defense but didn't ask for the charge on it. That seems pretty specific insofar as making an argument goes.
making a meritless motion is not deficient performance. It doesn't follow that a defendant has to make every possible motion. And
Would
ask
it
for
be
every
deficient
possible
in your
charge.
mind not to request a charge on what may have amounted to the appellant's only defense?
Well, that would be belied by the record because he did request and receive a charge on accident. So whether or not that was good judgment or not has not even been raised. But it's clear from the record that he did request and receive that charge. So it was not his sole defense. And I would...
Steele already addressed this. That's so funny. Detective Mowry says, dude looks like the professor that turned into a werewolf in Harry Potter. I was at a Christmas party, or a Christmas gathering, I guess. And there were like 15 kids there. And when they weren't bullying me, they were watching that exact movie. That's Remus Lupin. The only reason I know that is because I watched that like 2 days ago.
I would add that, and I've raised this point in my brief, he did not enumerate his error. Carter did not enumerate his error separately, the charge wasn't given sua sponte, so that issue is waived.
What's your response to Mr. Steele's argument about the complete defense of justification? You argue in your brief that it wouldn't have mattered whether he got in the justification charge anyway because it wasn't a complete defense.
That's true, particularly so in this case, because the defendant testified under oath that once he returned to his vehicle, he was safe.
I hated this
So he was safe to inform law enforcement, safe to do any other number of things. I heard the language up here. This is ridiculous. What is ridiculous is someone striking and killing a man.
Okay, the reason I assume he felt safe once he got back into his car is because he could then drive away. Like, that's the safety that a car offers, is mobility. Not, I am sitting in my car and I feel safe because I'm going to continue to sit as I'm attacked by a crowd of 100 people. That doesn't really make sense.
Going back to his car and in that safety deciding, no, I'm not going to get help. I'm not going to call the police.
Yeah, I agree. Panel not asking questions about son.
I'm going to go home and drink some more. And that is not justified. And under the facts of this case and the case law, as long as the defendant has other options than breaking the law, which he did have here, he could have stayed in his car and called the police. He could have driven off and gone to the police station. His conduct is not warranted, and he is not entitled to a charge on justification.
What's the record evidence that he asked people to call 911?
There is none except for his own self-serving testimony, and that's another reason why there's...
Yeah, but somebody did in fact call 911. That would also be evidence of misrepresentation.
No demonstration of deficient performance here, because a reasonable lawyer can doubt that the jury will credit their client. And I think we have that here in this case, especially since his testimony was undercut by other evidence. Particularly, he made the absurd claim that 100 people attacked him. Any reasonable lawyer could say, no, the jury is not going to buy that.
Well, but what did his lawyer say at the motion for new trial hearing about that? Not what any reasonable lawyer could say, but what did his lawyer say?
His lawyer said, in hindsight, maybe I should have asked for the charge, if I'm remembering the hearing correctly. But that's not the standard. Hindsight has no place in a claim of ineffective assistance, and it doesn't matter that the lawyer adopted that strategy or not. As long as any reasonable lawyer could adopt that strategy, then that claim of ineffective assistance fails because it is an objective test. And Additionally, there is case law that since the circumstances were of his own making, striking and killing a man, he's not entitled to a charge of justification. And I do believe that he is not entitled to one because it doesn't provide a complete defense, and he also had other options. Regarding Harbuck, that case is not even applicable. That's a case of felony fleeing. It doesn't have all the other steps that a defendant has to take to avoid getting that charge. So it's just the fleeing.
Yeah,
so it doesn't shed any light on whether or not a justification charge was warranted in this case.
Presented it as a
and in another case, which was referenced in the brief, Luke, any justification regarding fear of force must relate to the victim, not by unknown third parties. And I believe both parties have cited that case.
That's true, Aaron. That's a fair point.
In the briefs. Moreover, I don't believe there's been any demonstration of prejudice, and I would rest on my comments in the brief that we just heard a recounting of the facts at trial. That's not a demonstration of prejudice. I don't think there can be in this case because it all rests on the self-serving testimony of the defendant in this case, who was not credible and whose testimony was undercut by other evidence. This case was indeed overwhelming. There's no doubt that he struck and killed a person, that he fled the scene to drink more alcohol and except for a certain amount of self-serving testimony, never attempted to help the victim. So I think that is the argument as the state has presented it to you. I don't have anything.
Can you address, since you have a little bit more time, can you address Mr. Steele's comment about, or argument about the response to the jury question a little bit more? Because what I heard read by Mr. Steele used the word justification when he was the judge was responding to the question by the jury. If you look at that in context of the DA arguing justification and the defense attorney arguing justification, does that lend more credit to...
Sorry, I got to read this. The last time I was called jury duty, the one and only question asked, do you believe you have the right to defend yourself during the commission of a legal act? Wild answers from jurors. I bet. I would like to hear that. That sounds like a good time.
His argument that the judge should have charged justification.
I don't think so, and for a couple of reasons. One, it actually wasn't argued in the briefs. They were argued as separate issues.
That's not the question.
And I don't really see that proximate causation really has much to do with justification in this case. And the argument from the defense on appeal is that the answer to the jury's question should have been on proximate causation. My first response to that is the jury didn't even use those words. They asked, well, if the decedent contributed to his death, is he still guilty? And what the trial court did, which was proper, was recharge on the elements of the offense and simply read the statute and told the jury that they had to find that the defendant had to have caused the accident. And then he recharged them in writing on the issue of proximate causation. And his oral recharge did include the requirement that it is the defendant that has to cause that accident. So
was his reference to justification a misstatement of the law?
His reference to justification?
His reference to justification when he was answering the question, was that a misstatement of the law?
There was no question that I recall on justification. It was on whether or not the decedent contributed to his death. Would that be vehicular homicide? There was no reference to justification
in the answer. I thought when Mr. Steele read from the transcript that there was a reference to justification, that he had to stay there, something about he had to stay at the scene.
Yep.
But I may have been confusing.
I think he may have been referencing the prosecutor's comments. I believe what he may have been referencing is the judge's recitation of the statute, because the judge did read the hit and run statute in its entirety, and did include that language that in any instance the driver shall remain at the scene. But that's taken directly from the statute, so it's not error.
Okay.
If there are no further questions, the state would rest on the briefs.
All right, thank you, counsel.
Thank you.
May it please this honorable court, I am Brian.
Okay, so that was, I thought, an interesting one. It was some good work from Steele. It seems like a difficult case, but I think he made a strong argument. Still no, well, let me actually check, make sure that I'm not going to... It's been down today. The Court of Appeals website. All right, never mind. We're going to... I don't know. It hadn't been decided last night, so I'm assuming it hasn't been decided as of today. Any thoughts anybody has on that one? Two awesome arguments. Yeah. Yeah, I will say that's not enough tabs open for you. I actually, this is my like streaming browser. I actually have several other open windows where I keep my tabs, just so you guys can't call me out for having too many tabs. Have you got answers to the other two cases Steele argued that we watched? I need to go back and check. I can't even remember which ones they are. Hey, Kat. What were the cases... I should do like a check back and look at the... That's a good idea. I'm actually going to add that to my list. I'll go back and look at all the things that I've watched and give updates on decisions. Usually when I show stuff, I have the decision already. Like this next one we're going to watch. Oh, wait. No, that's my to-do list. Where are you? Ah, here we go. Okay, there we go. Oh, actually, I didn't mean to be on this tab, but I will show you. So this is January 20th. Booze versus State involves drinking. It's argued by Noah Pine, who's on Twitter. Some of you might recognize that name. Lee versus State is argued by Steele, and I can't remember who this one is going to be argued by. I haven't looked at this one yet. I don't know if it's a name I recognize. Let's do docket search. It looks like it's a habeas. No, not you. This website's been running so slow today. Okay. Well, let's go back to this one. And then the third, both of these are being argued by Steele. Medina versus State and Larkins v. State. So we're going to have 3 Steele cases in the coming 5 weeks, I guess. Arguing 2 cases on the same day is pretty wild. I don't know if I could do that. Fred Head is the warden in Butts County? I can't remember what prison's there. But his name is Fred Head, and I thought it was important that you guys knew that. No particular reason. That timestamp say August 25. That's true, and that's true. Yeah, he was, I think. Man, why is this running so slow today? Oh, wait, this isn't even the right website. I need to go to the Court of... No, I am on the right website. Docket search. Must be doing maintenance or something. Okay, so this last one we're going to watch is... This is a disbarment case. Christopher Casey Taylor is the name of the attorney. Actually, maybe I can pull up the... Oh, wait, no, I don't think I can get the briefs. but I do have the opinion. So this one was decided, I think, like 5 or 6 days ago. So we'll be able to go through the opinion after this. GSU Grinding described essentially the defense lawyer argument as a nightmare scenario because the facts are just so bad that it's impossible to argue. I tend to agree. I usually agree with GSU Grinding. Someday we'll get him to reveal his secret identity. Make it a little smaller here. Oh, actually, one of the things you'll notice is this on the right here is Judge Land, who was in the Court of Appeals in the first opinion that we watched. The Pinson and what's her name? Was it Jackson? I can't remember her last name. The two redheads are my top two. But okay, so this is a disbarment case. The first person's essentially like a prosecutor. The second person's essentially like a defense lawyer. The Supreme Court decides disbarment cases. It's not done by the trial court. So this is kind of like a trial for a disbarment case. So it's not like anything we've watched on this channel before. One of the things that's funny about this case, and really like Court of Appeals in general, is when you get the court asking these kind of like intellectually interesting, abstract legal concepts instead of getting into the facts of the case, a lot of times they've already made up their mind based on the briefing. And you kind of see that in the first, when the prosecutor who goes first is presenting her argument. They're going to be asking these kind of like philosophical legal questions as opposed to getting into the specific facts. And then contrast that with how, keep that in mind and contrast it with when the defense lawyer is going and the questions they ask of him. This is a beatdown. Let me put it like that. This is brutal. This is this is nightmare fuel for sure for defense lawyers. Okay, let's get into this.
S24Y.
I can't remember his name. I can't remember who that is.
In the matter of Christopher Casey Taylor, Andrea Morrison for appellant, Jerome Lee for appellate.
See if I recognize anybody. Oh, she's an ADA. I know what case they just argued. This is right after the case. What was it? Oh, it's gonna drive me crazy. I know what case this was. I think we watched it on the stream before. She was a brand new ADA. It was about the statutory speedy case. I think we watched it like 2 months ago. It was a statutory speedy trial case in Columbus County. Maybe 3 or 4 months ago when we watched it. They use AI. No, this was a case. It was an immigration lawyer, and he basically just abandoned his clients entirely. He didn't supervise. He was the head of the firm. He didn't supervise anybody. He was just basically a scumbag.
Ms. Morrison, you may proceed when ready.
So this is basically like a prosecutor.
Good morning, and may it please the court. My name is Andrea Morrison. I represent the State Bar, along with Russell Willard and William Hermberg. We are here today because respondent harmed his clients, violated the ethical rules, and failed to take responsibility. The court asked the parties to focus on 3 issues. First,
the first one, how. The second issue, dare. Third issue, you. How dare you?
The implication of respondent's admission that the record supports a finding he violated 5.1 in all the cases. Second, the proper application.
Oh yeah, this is actually 6 different cases. They brought 6 cases against him for misconduct. That's why the case number is a hyphenated number there. It was 12, 48, 49, 50, 51, and 52.
Application of Rule 5.1, excuse me, when an attorney enters an appearance. And
If there's any kind of prosecutor that I would like, it's somebody that prosecutes lawyers, for sure.
third, respondent's level of involvement and responsibility.
It should be way easier to get disbarred, by the way. Like, Tyrone Blackburn, he needs to be done. Like, some of these lawyers aren't even trying. Like, it should be way easier to get disbarred.
For the cases as it pertains to the remaining
Hey,
rules.
Christine.
Let me address those in turn. First, respondent's admissions and the record do support a finding he violated 5.1 in all the cases. The court is therefore authorized, pursuant to the Crowther case,
Like, Moontung's case, there need to be... I could name you, like, 5 lawyers that should be disbarred because of that.
to use that in aggravation.
Hey, Christine, welcome.
And that would justify enhancing the special master's sanction. Second, by entering an appearance in all but one case, respondent fell directly under the obligations of Rule 5.1b. He acknowledged responsibility for the case and the clients, and it triggered an obligation to supervise the more junior lawyers working on those cases. And third, this wasn't just passive oversight. Respondent, either through his direct conduct or conduct he authorized, was deeply involved in these cases. Which brings me to the broader issue. Respondent wants to have it both ways. When the special master said suspension, he asked the review board to throw it out. Now he's asking this court to go back and impose suspension. But the review board was correct. And while the bar initially supported suspension, in retrospect, looking at the record, his admission, and his continued aggravating conduct, disbarment is not just justified, it's necessary.
Okay, let me explain. How much is the membership? I think it's like $4. It's whatever the default is. I didn't change it from the default. Okay, so I just want to give background on what she's saying. So there are basically 3 steps to disbarment. The first one is there's a special master, and they do like an initial review of the facts and do findings, and they make a recommendation. And in this case, the special master recommended a suspension for, I think, 6 to 12 months. The lawyer said, no, I don't want a suspension. You should throw that out at the next level up, which is the review board. And it's like a board of people that review, as the name implies, they review the special master's work. And the review board said, we agree with you. You definitely shouldn't be suspended. You should be disbarred. And that would be the find out phase. And at that point, the lawyer said, no, I should be suspended. So now he contested the suspension, and then when it got escalated to disbarment, he said, no, I want to be suspended. That's essentially what she's getting at. So him saying I should be suspended is a little hollow in this context. That's not really accepting responsibility.
I'll turn now to, more specifically, to the issues the court wanted to address.
Counsel, in doing so, could you help? I think we all recognize that we learn as we go through the process sometimes in what amounts to a prosecution sort of posture. But why was there anything specific in this case that caused the 5.1 charges to be brought in 2 and not the 4, as it were? In other words, was there anything different about the record as it stood at the point of charging that drove the decision not to charge the 5.1 in the 4 where we don't see a 5.1 charge? Or was it just totally a choice in the process?
Absolutely, there was something that made that determination. The first 3 cases that were charged were filed in January of 2022. Prior to that time, the evidence showed that respondent alone, other than some attorneys appearing in court, was the one responsible for the cases. At that point, there wasn't an indication of a systemic failure to supervise. Respondent was then deposed in those first 3 disciplinary cases. At that time, he testified regarding systemic failures to supervise and failures to have procedures in place to ensure that attorneys at the firm were complying with their ethical obligations. He called the other attorneys self-supervising. He indicated that everything could be signed under his name without him reviewing or drafting. So at that point, there was a determination of these systemic failures and these violations of Rule 5.1. However, at that time, the bar was precluded from going back and amending the complaint. The bar rules prohibit that. Specifically, Rule 4-204.1 requires that
Oh man, Aaron, I know, right?
a notice of investigation that goes to the state disciplinary board, identifies the rules.
It's like my golden retriever is self-supervising. It ate the turkey. What can I say? It's
Allegedly
self-supervising.
violated, so that the respondent has a reasonable notice of the charges against him and a reasonable opportunity to respond. In the matter of Ruffalo, the U.S.
So in other words, you could have, but you would have had to go back to the beginning. There's no amendment midstream. It's a new conferral of due process from the outset.
Yes, Your Honor, and
in cases that are already farther down the line.
Yes, and the U.S. Supreme Court stated that in the Ruffalo case, where it's...
You know what's funny? I just realized this. Essentially, these questions are like, why didn't you charge him with more stuff? That's really what they're asking. They're saying you charged him with misconduct, with a specific type of misconduct, 5.1 violation, and 2 out of the 4. Why didn't you charge him in the other 4 too? It's not even like we're doubting that you proved your case. It's like, why didn't you prove more stuff? This guy sucks.
Held that discipline cannot rest on charges first arising out of the lawyer's own testimony. This court has also applied that same principle most recently in the matter of Roberts' case. In that case, the court found that there were no due process issues because the rules had been pled, they had been alleged, and that lawyer had sufficient opportunity to respond. But his admissions before the court and the record before the court on those cases where 5.1 wasn't charged still matter, and here's why. In his exceptions, he acknowledges, first, that the record could support a 5.1 violation, that he failed to supervise his associates, treating them as, quote, self-supervising, and that his firm's structure during that relevant time did not satisfy his professional obligations. I do want to note that these acknowledgments and admissions were only made in the face of a disbarment recommendation.
Counsel, what's your response to what seems like an argument from the other side along the lines of this is just how these practices are run? This is just how law firms of this type are run. Does the bar have a response to that?
That is insufficient to
Just to preview what the other side's going to argue, they basically said that immigration law is different from other kinds of law. And so you should look at his firm differently.
Comply with one's ethical obligations. Merely having a law firm run that way does not mean that there are not ethical violations, ethical implications, and that there's not harm that comes out of these failures to have procedures in place, to have a process to ensure that junior attorneys, to ensure that other partners are complying with their own ethical obligations, to ensure that other staff is complying with their ethical obligations. He was the owner of the firm. He was the managing partner. He called himself the face of the firm. And so his acknowledgments, I will point out, are somewhat incomplete because in the briefs before the court, while saying there could be, the record could support a finding, he also disputes that there are rule violations. He says the results of these cases are as much a function of the harsh realities of immigration practice as any action or inaction on the part of the respondent or his firm. That, to me, is a belated and insincere posture, and that is something in aggravation. So the court...
Just for more context, one of the things he argued was that his cases were hopeless anyway, and that his clients had no chance of winning, and therefore it was harmless error, basically, because, his clients were going to lose, so you shouldn't, worry about whether he violated his obligations to them. Just talking about the kind of guy we're dealing with here.
Pursuant to the Crowther case, which was a court issued last year, can, however, use that, even without without finding new violations, can use it in aggravation.
So where's the line between that and essentially using in aggravation the fact that you're defending yourself? Like our case law clearly says, like in Crowther, that we can use things like this in aggravation sometimes. But our case law also makes clear that you can't be worse off for choosing to defend yourself through the process. Where's the line between those two ideas?
There is indeed a line.
I really
And
like Peterson too.
when a lawyer is obviously entitled to defend themselves against charges of ethical misconduct. But here we have much more than that. We have a complete lack of remorse and lack of accountability. If you take a look.
Well, but how can you defend yourself and simultaneously show remorse for things that you're saying that you didn't do? Like, how does that work?
Well, if before the court, respondent is making admissions and acknowledging that there was systemic failures in his processes, then he is attempting to show remorse. And if you look at the ABA standards in mitigation and aggravation, that is something for the court, for the special master, for the review board to consider in imposing the appropriate level of discipline.
So on that point, if a lawyer comes in and says, I did not break this rule that I've been charged with, and my evidence for why I didn't break this rule is that I broke another rule. And in fact, I didn't break what you did, I violated another rule. If they are right, they have won. In other words, if they can demonstrate I did not break this first rule, and my evidence for that is showing you how I broke a different rule, they've won, because we can't amend. They might be another disciplinary process coming or other consequences, but they've won that argument. But if they get in the posture of saying, well, I lost, I did in fact break the first rule, and even though I've now admitted to breaking the second rule, I think the question is can that second rule that they've now admitted to breaking, in an attempt to demonstrate that they didn't break the first rule, if they're wrong, can it be used in aggravation in that context?
Yes, it can. And I will also note that a respondent does have the ability to file a petition for voluntary discipline at any stage, either before a formal complaint or after the formal complaint, in which they admit sufficient conduct and rule violations. That's not what we have here. We do not have a petition for voluntary discipline. If we had that and the respondent, admitted violations of a different rule and had sufficient facts and admissions of conduct, it would be appropriate then for the court to impose discipline on that rule. But that's not what we have here. Here we have essentially respondent wanting this to go away, because now we have a disbarment recommendation, and he's saying, well, maybe now the record supports a finding that I'm engaged in some misconduct, so let's go back to a suspension. That's only in the face of a disbarment recommendation, whereas throughout these proceedings and after the special master's recommendation, he has shown a lack of remorse, a lack of accountability. He's made attacks on the process. He's made attacks on the grievance. He's called the claims meritless. He has indicated that these
I mean,
claims...
to be fair, if you think if you're not guilty of something, you're going to call it meritless.
He's called his client's claims meritless and indicated that they were not going to prevail regardless.
I don't think it's an example of great behavior. I mean, the multiple motions to compel in the discovery process, this is not a cooperative effort. But what I'm trying to get to is the basis for using a separate uncharged violation in aggravation. And I'm not disputing. I'm just trying to make sure I understand the bar's posture on why it's okay to use it in aggravation, though it wasn't charged. If the defense is, I didn't do this violation because I did another violation. If it was different, where you were saying I didn't do either, right? If that was the defense, I would say, yeah, if we found that there was evidence to support it, that would be an aggravating basis. But if the defense is, I didn't do the one, and the reason I know I didn't do the one is because I did the other, I'm trying to understand why it would be aggravating as to the one that your argument failed, but you're allowed to make the argument that the one doesn't apply.
Well, what we have here is a finding by the special master and the review board that there were in fact other violations. So in addition to those violations, we have this further admission, alleged admission in aggravation. And that is why under this posture, because there already have been rule violations that have been found by the special master and affirmed by the review board, the admission, the further admission combined with the record before the court that shows violations of 5.1 could be further used in aggravation of the sanction that was initially recommended by the special master. The special master didn't conclude that there were no violations, and now we're dealing with an uncharged rule with no additional violations that were found. I do also want to go into issue 2 that the court wanted to address, and that is the proper application of Rule 5.1 when an attorney enters an appearance in the case. So we've already talked about respondent's obligations as a partner, as a face of the firm, but it's very important that in all but one of the cases, he entered an appearance both before the immigration court as well as the Board of Immigration Appeals. Now, Rule 5.1 is broken down into the 3 key responsibilities. 5.1a deals with a lawyer's obligations to ensure that there's processes and procedures across the firm. Subsection B deals with direct supervision. When a partner, a supervisor is involved in the case, they now have a responsibility to ensure that the more junior lawyers are complying with their ethical obligations and properly representing their clients. And then subsection C as a vicarious liability application. When he filed an entry of appearance in all but one case, it had 2 immediate consequences. First, it showed an attorney-client relationship. He was counsel of record in the eyes of the court. It triggered accountability before the immigration court. This has been noted in our brief, but under the EOIR Policy Manual Section 2.3, when multiple attorneys appear in a case, each is a representative of record, and each bears full responsibility for the representation.
Yep. This is
so
very,
you can't claim that he had no obligation.
This is like very basic stuff. This is stuff you learn like in your first year of law school in ethics. If you're there's no like, Mobb Deep said there's no such thing as halfway crooks. It's kind of like that, but for lawyers. You're either in or you're out. If you make an appearance, you're responsible for everything.
For these cases, he filed an entry appearance in all but one, and I want to address one argument that he's made, that he filed them for administrative purposes so that the firm could receive notices in case another lawyer left the firm. But I think that argument actually cuts against him, because by filing an appearance and appearing as counsel of record, lead attorney, it showed that he was intending to carry forward with the representation in these cases, especially since, as we all know, immigration cases.
It's kind of funny because she's like, it's really hard to argue something that's exceedingly obvious. Because what do you say? Like, the guy entered an appearance as the lead attorney in a case, and now he's like, oh, well, somebody else was on the case, therefore I'm not responsible for it. Like, how do you argue against that? Other than just... like, what do you say? What do I know about Mobb Deep? I'm just a shook one.
Can last a long time. So once he entered an appearance, the 5.1 obligations became case-specific. And because it made 5.1 more concrete as it applies, his failure to do that, his failure to do anything and essentially wash his hands.
Would 5.1 B and C have applied if he hadn't made an entry of appearance?
If he hadn't, not necessarily, because at that point he still had the 5.1A obligations to ensure the processes and procedures, but because he didn't enter an appearance in each particular case, he wouldn't have had that direct supervisory responsibility.
The B and C requirements arise only from a lawyer who's actually part of the
in the case.
Right. Okay.
Yes, Your Honor. I do want
that may also then be the case with respect to the Chevrolet, the 7634, right, where there was never any appearance of any sort entered. I mean, but the special master found that he was in fact the attorney. He participated in the meeting. Because there's never.
Honestly, like, what I do, how I get these opinions or oral arguments to watch on the stream is I watch them on my own anyway, and then whichever ones I like, I share with you guys. So I would have been watching these either way. So I enjoy doing it.
Or any appearance, there may not have been a supervisory responsibility in that case.
Correct, Your Honor. And in that case, we did not charge a fine.
No, I know you didn't charge it, but I'm talking about the aggravation piece where you were going back.
Yes, yes. The record shows.
It is funny. It seems like, how can I put this? It has the tone, and like if you just listen to the tone of voice, it seems like they're disagreeing with her, or like arguing with her, or like, you know, questioning her conclusions. But that's not really what's happening. What they're really being is like, I want to fully understand all of the ways in which this guy violated his ethical obligations. They just want to, like, they already know that he did all this bad stuff. They just want to make sure they're really wrapping their heads around all of the nuances of the ways in which this guy is going to get disbarred, so they can like really disbar him, because they're not really disagreeing with her. They're just trying to flesh it out. Exactly. See, if I'm trying not to curse for you know, for the algorithm, but if I could, I would, yeah, I would. Like the tone of voice is that they're disagreeing and pushing her, but they're not. No, you can say it. I don't care. I don't care if I say stuff. Would it? I don't know. We'll see. You can say curse. I don't care.
You may answer the question.
The record shows that he had involvement in all the cases. Thank you.
All right. To be fair, I think the guy that argues for the lawyer actually did a pretty good job, but like, it's like trying to defend a toddler that has chocolate smeared on his face and being like, he didn't eat the chocolate. It's not going to go well for you.
Mr. Lee?
In the first minute or so?
Good morning,
Okay.
please, the court. My name is Jerome Lee, and I have the pleasure of representing
He did not have the pleasure.
and defending Mr. Taylor in these proceedings. And from the beginning, I will have, sorry, getting used to my reading glasses, but
You're not the only.
I really wanted to say he fucked around and found out when he contested the suspension only for the review board to agree with him to be like, yeah, you shouldn't get suspended. You should get disbarred. That's the funniest thing I've ever heard.
The one in that camp.
Oh my goodness, that's so funny.
But I will take questions or interruptions from the very beginning.
You love to see it.
Self-supervising mean when you're signed up as?
I just love that. He says, I welcome it. Usually you get 2 minutes to not get interrupted. That's kind of more of a guideline. But it's like, you can interrupt me. Boom. Immediately questions.
Camp.
Yeah. But I will take questions or interruptions from the very beginning.
So what does self-supervising mean when you're signed up as counsel in a matter and the claim is, well, they were self-supervising? How is that in compliance with the rules of professional conduct?
Well, it fits because we are a small firm, and that group is even a smaller portion of the firm. And the individuals in that firm are all senior attorneys, and the measures and means by which they regulate each other since, I think about 2013 from the record, when the individual that was in the direct supervisor of the entire group left the firm. When the change took place, it was decided that the group would essentially govern and run itself. So the 4 senior attorneys that had done hundreds and hundreds of these cases essentially took responsibility for checking and managing each other.
Counsel, you say small firm, and I understand that from a number of attorneys' standpoint, but my understanding of looking at the record is that Mr. Taylor testified, I mean, that he had 10,000 open files, open cases at one time where he was counsel of record. That doesn't sound small to me. Is that a small number of immigration cases to be counsel of record on at any given time?
Yes, that is a bit of hyperbole from Mr. Taylor. I think the proper way to think about that.
But it is in the record.
Yes, it is there. But I don't think it is entirely accurate.
Oh God, it's a discipline hearing. It's not a good time to be like, he's telling the truth, but not a good thing to be saying. Yeah, he was telling the truth about that.
Size of the firm impact the responsibilities under Rule 5.1?
It doesn't.
In other words, if I have a singular associate, I'm a practicing attorney, I bring in a singular associate, does 5.1 apply differently?
Absolutely.
How is that? What's your authority for that?
There's a case out of South Carolina, the NRA anonymous attorney.
Oh man, you're going to a different state. That's not great.
The site is NRA anonymous member, South Carolina Bar, 25346, 2001. That is the best case we've seen.
25-year-old out of state
and analyze the 5.1 requirements and how it works, how the double reasonable on each end of that requirement affects what you can expect in terms of what it means to be reasonable.
South Carolina's rules the same as ours?
Welcome.
They're both analyzing the ABA interpretation of 5.1 and the model rule.
But in any event, you acknowledge that at least in 5 of these files, he failed to meet the 5.1 standard.
I would say that there were universal violations.
Your written filings in this court indicate that in at least 5 of these cases, he failed to meet the 5.1 standard.
Well, technically speaking, Judge, only in 2 were the actual allegations.
Didn't ask whether he was responsible for them. I'm asking, you have said, you acknowledge that though they weren't charged, he failed to meet the standard. I mean, I appreciate the State Bar's argument that one of the matters in aggravation is this continued effort not to be responsible for what you have already taken responsibility for. Well, did he or did he not fail to meet the 5.1 standard in the 5 cases, not the Echeverry case where there was never an appearance entered? Did he fail to meet the standard? I didn't.
You think so he knows all 6 cases by name, by the names of the parties, and he knows the rules violations associated with each of those 6 cases off the top of his head. You think he might have looked into this? He might be a little unhappy with the attorney. I think he might have been. I like seeing lawyers get held to account like this.
I'm asking, you have said, you acknowledge that though they weren't charged, he failed to meet the standard. I mean, I appreciate the State Bar's argument that one of the matters in aggravation is this continued effort not to be responsible for what you have already taken responsibility for. Well, did he or did he not fail to meet the 5.1 standard in the 5 cases, not the Echeverry case where there was never an appearance entered? Did he fail to meet the standard? I didn't say whether he can be responsible for them because I know there's only charged in 2.
I think the answer to that is yes, Judge.
Thank you.
Yeah. And so that was my point, though. But the nature of the violation depends on the size of the firm and what's reasonable for the size of the firm and what they're doing. So
well, there isn't like some, ephemeral test for this. Isn't it just whether you are able to adequately discharge your obligations to your clients through your supervision or through your direct conduct as counsel?
That is correct, but...
So can one ever do that with 10,000 appearances?
I love the way he says that is correct.
That is correct, but...
So can one ever do that with 10,000 appearances?
Well, that's the problem with that is the second part is that they're not actually 10,000 appearances. So
5,000?
It's not even that. So
are you suggesting that a supervising lawyer in a small firm has less of an obligation under 5.1 than a supervising lawyer in a large firm? Is that what you're arguing?
I am not arguing that it's less. I'm just saying it's qualitatively different.
And so how is that? How would we ever discern what is appropriate if it's different, but the standard is the same?
Well, it's because of the way that you would implement the actual measures, Judge. So when I'm at King and Spalding, there are things that I do. I report to my immediate supervisor and partner, and then if there's an issue, there's a team partner that handles things, and then beyond the team manager, there's the local manager.
Can a paralegal ever be self-supervising?
No, absolutely not.
So, but this is a really interesting position that seems to be, is a very shifting sand throughout this. Mr. Taylor's testimony and the argument throughout has been, I'm not responsible for the 1.1, the 1.2, or the 3.2 because I wasn't counsel. In fact, I was never really actually counsel for anybody. I was only ever the face. I was only ever supervising. My only job was to bring in business and supervise attorneys. But you can't hold me responsible for supervising the attorneys. What else was he, if he wasn't actually representing the people, which is dubious, and I think the special master's findings of fact are supported, but fine, if he wasn't representing them, he was supervising them. If he wasn't supervising them, then he entered an appearance and didn't do anything. Those two things don't fit together, do they?
They do, and it's because of the nuances of immigration court. So because these cases can take a decade, if I only place a case...
It's a misconduct case, and your position is that your client just didn't do anything despite being counsel of record. That's a tough one.
In the name of the lawyer that is actually handling the case.
You can put the name on the pleading and put a generic email address that's monitored by the entire firm over the course of time.
Well, the immigration court doesn't really use email to serve.
You can substitute counsel when you have turnover at your firm.
You can, but a lot of times if someone's been there 7, 8 years, Judge, there could be hundreds of cases that could be under that person's name.
Whose responsibility is it to track those things?
Yes, exactly.
The firm's procedures and software and technology and the like process
And
track
each
those
individual attorney who is counsel of record, right?
Yes.
So when your name gets submitted to a court or adjudicatory body,
It doesn't
as
sound like
counsel
he's
of
winning.
record
It
for
does
another
not.
person, it doesn't. I mean, it's nice to have protection from your firm. It's nice to have your firm's policies, but that is your name on the record, and you are responsible for that person until the court or adjudicatory body releases you. Yes?
That's correct.
Yeah, exactly. I completely agree with that. If it's your name's on the record, you're responsible. End of story. That's how you keep clients from falling through the cracks. That's the whole reason why you have specific attorneys assigned to cases, is so you have somebody hold accountable. And in theory, if you know you're being held accountable, you won't leave your clients to, leave them to sink after you leave a firm. These judges aren't very poker faced in these hearings. They are not, especially this one. I think it's pretty clear they decided on the briefs.
So all of the 1.1, 2, 3,
which is fine.
His name and signature are on all of those appearances. Regardless of why they are on there from the firms, I mean, what I'm trying to get at is, I think the question that was asked to the bar is, how can a firm's structural decision about how they manage their business alter an attorney's responsibilities under the Georgia Rules of Professional Conduct?
Yep.
Well, I think the most important thing to remember here, Judge, is that there are multiple entries. So it's not just Mr. Taylor placing an entry on a case.
Just because there are other people on the case doesn't mean you're not individually responsible for everything.
So in a given case, there'll be an entry from Mr. Taylor as notice attorney saying this is a Taylor Lee and Associates case. Then another attorney will be assigned to come in and be like, okay, I'm the attorney that's actually handling all the appearances.
Do the bar rules contain a distinction between when there's multiple lawyers on a file? Does it say that only the lawyer who says they're the lead lawyer or what have you are responsible under 1.1 and 1.2 and 1.3? Or is every lawyer who's made an appearance a lawyer for those rule purposes?
And see, I think that's the problem. If the rule is the latter, Judge, then I think that you end up with a draconian result where if something goes wrong in a process and the attorney puts in an entry to do the individual, which is the merits hearing at the end of the process, then if that attorney does something wrong, then by that rule, as you've articulated, every single lawyer who's ever put in an entry is suddenly responsible for something.
If they're still on the file, I mean, what's your best case for that not being the rule?
So the best case for that not being in the rule is a case that came out of the Ninth Circuit about 2 years ago.
The Ninth
that
Circuit?
highlighted the ability of
That's
entry
California.
of appearances in immigration court.
Okay, now we're talking about presumably California, Oregon, Washington, Idaho, Utah, Arizona, New Mexico, I think. Case, maybe New Mexico? I'm not sure about that one. So it's on the other side of the country. Federal court, apparently, not even a state court. Yeah, this is not very convincing.
To serve multiple purposes. Okay. So the generic G28, E28, E27, whatever you want to call it.
Counsel, try to stick by the mic if you don't mind.
Sorry about that.
Thank you.
Do you have a cite for that case?
Did he bring any Georgia law? Probably
Give me a
somewhere,
second
but
here,
none of
Judge,
things
let me
mentioned so
find
far.
That's in here.
And to be fair, I think he's doing like the best possible job that he can do. I don't think he was involved in the previous stuff. I think he's just arguing this case right now. I think he's doing as good a job as he can do, but his client's just out of luck.
It is NWIRP and Yuk Man Maji Ching versus Sessions, 2:17 CV 00716.
This is an unpublished district court order?
It is a district court order, but it was ultimately
He must have been doing some deep research
either
to find this one.
affirmed or they denied.
We get Dr. Robotnik's approval in the back here, which is nice.
A notice of appearance could serve more than one purpose, which very
Wait, did I go? Yeah.
Yuk Man Maji. It is NWIRP and Yuk Man Maji Ching versus Sessions, 2:17 CV 00716.
This is an unpublished district court order?
It is a district court order, but it was ultimately a.
Same, bro. Same.
Either affirmed or they denied cert.
Well, I mean, even if a district court acknowledges that a notice of appearance could serve more than one purpose, which very well may be true, it doesn't change, I would assume, what the internal immigration procedures are for what that means, that you are responsible in the case, right?
It does, in the sense that.
Does it change if you enter an appearance and you're like, hey, I'm your lawyer, I gotcha, and you say that to the client?
Could you repeat that question for me, please?
So there's one set of scenarios where all you do is merely enter an appearance, and we can discuss what that means under the immigration internal rules or otherwise. There's another scenario where someone enters an appearance as counsel, but actually has contact with the client, or someone else at the firm represents to the client that person is the lawyer for the client. In that scenario, doesn't the entry of appearance obviously mean more?
No, because the converse is true. If Mr. Taylor hadn't filed an appearance in any of these cases, he'd still be responsible as a permanent partner of the firm.
Well, that seems to cut against every argument you've just made.
Yes.
No. What I'm saying is he is responsible for improvising procedures that assure a certain amount of.
Responsible under 5.1.
Yes. That is the extent of his responsibility under our argument for what the entry of appearance means.
If he doesn't enter an appearance.
Pardon?
If he does not enter an appearance. But he entered an appearance in all of these cases, so that has consequences.
It has some consequences.
It has significant consequences under the bar rules. He's their lawyer. Once you enter an appearance for somebody, you represent them. And why do you not take on all the responsibilities that every other lawyer in the state of Georgia takes on when you have a client that you've entered an appearance on?
He just cooked right there.
He did enter an appearance on behalf of his client, but so did an associate enter an appearance on the court.
That associate has responsibilities to the client. He or she enters an appearance.
That is correct.
And he's a supervisor, right?
But he is the supervisor. That is correct. So it's the same
So he
way
has
with
even
any
more
of the giant
responsibilities.
firms. You know, with Morgan & Morgan, John Morgan does not show up at trial.
I wouldn't use Morgan & Morgan as an example. Use anybody else.
If he makes an appearance, he's still on the hook for what happens.
He is,
It
but
makes
he is not.
It makes no difference what size firm it is. They still have an obligation. If you enter an appearance on behalf of a client, you've got obligations.
That's correct.
Why does an immigration lawyer get a pass from that and everybody else doesn't?
Because of the way the G28 is sort of written, and because of the way that the court actually.
So looking in your brief at page 11, where you talk about this case from the Western District of Washington that you cited to us, the point I understand you to be making is the federal immigration courts have their own process that allow lawyers to do sort of limited scope representation, largely for the purpose of access to justice and trying to enhance representation for unrepresented persons. Here's the problem that I think that creates here, potentially. The federal immigration courts aren't the only ones regulating the lawyers practicing before them. State Supreme Courts, through their bar rules, are also regulating those. And to the extent there's conflict between the regulations, presumptively both, the obligations from both entities still apply unless you have some supremacy clause argument that the federal dispensed with the state ones. And so it may be that there is a pattern in practice that the immigration courts have created that is inconsistent with the state bar rules. Is that kind of your position?
I think, yes, that it is. There are different rules and that there is some tension between the rules. And in a case like this, where this tension has not been addressed by any court in any of the 50 states that we could find, this is entirely a new and novel issue. And so for us, it is sort of the equivalent of, in the criminal setting, people will come in and just enter an appearance do the bond hearing. So if I lose at trial and I have to come back and file a bar complaint or a motion for new trial, I'm not going to invoke the person that did the bond. That person entered for a limited purpose, and that purpose was served, and that person's responsibility.
Well, but I think there's a different question here, which is it may be that a practice has emerged that allows certain things, and it may be that lawyers can routinely take advantage of that practice so long as it doesn't violate other rules. And if there is a question about whether it violates other rules, then if a lawyer continues to avail him or herself of this other practice, they may be subject to disciplinary consequences. And that seems, maybe it's the first time someone has brought it up, but there's nothing I have heard you say and nothing I can think of that would wholesale erase the obligations under the Georgia rules for a Georgia lawyer.
And we're not saying that they do, Judge. I think the most important thing that I kind of wanted to convey and get across was that there's an adjudication of a violation of 5.1, and then there's the punishment for it. And I think that the issue is we are saying that there were superficial violations of the rule under 5.1.
You're saying, or who is saying?
I think the argument in the briefs that we're making is that there were superficial violations.
You haven't even taken care of the 1.1, the 1.2a, the 1.4, there are multiple violations. We're not only considering the ones that you've admitted, right?
I would argue that without the 5.1, the others are attempting to impute to another lawyer behavior.
The special master found as a matter of fact that Mr. Taylor represented those people in the direct capacity.
He's heated, and I get it.
Not in a supervisory capacity. And you have to acknowledge that the record supports that it's not clearly erroneous because his signature is on their filings in court saying, I am this person's attorney.
Well, I think that's actually part of the issue and the reason why we did concede on the 5.1.
So bear with me for just a minute. What you're saying now sounds like, well, there's this way we don't understand, but you haven't litigated it that way. You initially sort of didn't participate. You slow played the participation. You didn't get your evidence in. You said, no, there's nothing to see here. And now all of a sudden you're saying there is something to see here, but it's just very different. It's a unicorn. But those things all took forever to come out. Why?
Why? That's a good question. I like that.
Well, I think the larger problem here is it wasn't that there was a delay in getting it out. Is that the proper questions were never asked. And so in a lot of these cases, while there is an analog from immigration cases to criminal cases, the analogy is not perfect. So for example, one of the big things in immigration court is when you come in, you have to concede removability or not from the very beginning, which is a quasi-equivalent of saying, I'm guilty. So you walk into the court saying, I am guilty. So these proceedings are very, very different than others. And so not only do you admit to guilt, what you then say is, but I have this minor exception that I think I apply for, and I'd like the chance to present that opportunity.
And we understand that difference. Before your time expires, can I ask you about one argument that you're making on aggravating factors?
Okay.
And that is prejudice to the clients.
This is a tough part.
One argument that you're making on the prejudice point, at least as I understand it, was that these cases were all losers anyway. And so whatever happened from the lawyer's side could not have prejudiced them. Is that your argument?
Essentially.
If they were dead bang losers.
You should be disbarred just for making that argument. And then readmitted and then disbarred again.
From the start, recognizing that the effect misconduct has on outcome is what our precedent says we look to for prejudice, does that potentially open a problem on accepting the case to begin with? I mean, if you take a client's money with no prospect for helping them, unless you have papered the record really clearly to say we advised them that there was no possible help we could offer and we took their money anyway because they insisted.
Turn up the volume.
Is that fraudulent? I mean, is there a failure to inform the potential client that they're paying money for nothing?
The answer to that question is no, Judge. And it goes to that these processes are oftentimes more elaborate. So even if I'm defending you in immigration court, normally the purpose of defending is to buy time to find an actual basis for adjustment. And if you go through our engagement agreements, all that's sort of laid out, and the things that we say we can do and what we don't do.
So recognizing that buying time is something of actual value, to the extent the claim here is that these clients...
I didn't hear that, Danny, but I'm incredibly unsurprised. Ooh, I want to listen. I want to go back and hear it now. I hope you guys don't mind.
Inform the potential client that they're paying money for nothing?
The answer to that question is no, Judge. And it goes to that these processes are oftentimes more elaborate. So even if I'm defending you in immigration court, normally the purpose of defending is to buy time to find an actual basis for adjustment. And if you go through our engagement agreements, all that's sort of laid out, and the things that we say we can do and what we don't do.
So recognizing that buying time is something of actual value, to the extent the claim here is that these clients were effectively abandoned, can't that affect how much time you could have bought them?
Well, that's the point. We're arguing they were not abandoned.
Okay. All right. Thank you, counsel. Ms. Morrison, I believe you have 4 minutes remaining.
Yes, Your Honor. So I agree that immigration proceedings may be different, but the application of the bar rules to immigration lawyers is not. We're talking here about a lawyer's responsibility to the clients. There was a lot of discussion about what effect the entry of appearance had in the case. What we have here, in all but one of the cases where there was no entry of appearance, is much more than that. What we have here is filings, letters, submissions to the court. And as far as the harm, Chief, you asked about if these cases, it was just buying time. Well, in a lot of these cases, the clients lost the opportunity to present their full case. There was a failure to submit documents within a 15-day period of the hearing.
If we only looked to the type of harm that your opposing counsel has articulated, which is there was never really a chance in the first place, wouldn't that effectively insulate this type of lawyer from ever suffering bar discipline on the theory that there was no harm to the client?
It absolutely would, because in imposing a disciplinary sanction, you're looking at the duties, you're looking at the mental state, and you're looking at the harm. And the harm in these particular cases, there was significant harm. I will submit
What was the harm? Because my read of our precedent is that typically in the harm space, when we're talking about effect on the representation, as opposed to stealing money from trust accounts or things like that, is that we tend to look at the difference in outcome. What's your best case for we look for something other than difference in outcome?
We have to look at what the clients, if they lost their ability to pursue a claim. So I would point the court to cases in which a lawyer didn't file a case within the statute of limitations.
Well, the record also has ancillary costs, right? I mean, there's record evidence that at least one of them, I think, paid $10,000 to another attorney to try and fix what they.
Yes, Your Honor.
He knows
Many
his
of these
record
clients
stone cold.
retained
I
other
love it.
lawyers in an effort to reopen their cases. There was one client where the appeal was never filed, and it was an asylum case. The appeal was never filed during the time, although the client was told the appeal was filed. The client hired another lawyer, paid thousands of dollars, and has since then had their motion reopened, and their asylum claim is still pending. There's another client in which the documents that were to be submitted within that 15-day window were never submitted, and so they were not considered by the court. And so these clients lost the ability to present their full case.
So one of the points that Mr. Lee made that I think is central to their defense at this point in the case is that this really is a novel intersection between the state rules of professional responsibility and the way federal immigration courts operate. Are you aware of another case addressing something like this? Certainly not from our court, but anywhere in the country. How novel is this really?
I am not aware of another case. I will end with the fact that I also think we have to look at this case. It is distinct from maybe other cases involving immigration practice, because here we have a high level of involvement and also a high level of failure to be involved at the same time. Everything was in his name. He wanted everything to be in his name. In the eyes of the court, in the eyes of the client, he was their lawyer. And in the eyes of the court and in the eyes of the client, he failed to adequately represent these clients and violated the rules, which justifies the recommendation of disbarment.
Thank you, counsel.
Thank you.
Thank you, counsel, to both sides.
That closing line was, if I was Cat Williams, I'd have like a fire like highlight right here. But I want to listen to that closing again. That was fantastic.
I am not aware
Fire overlay. That's what I was trying to say.
of another case. I will
This part.
end with the fact that I also think we have to look at this case. It is distinct from maybe other cases involving immigration practice, because here we have a high level of involvement and also a high level of failure to be involved at the same time. Everything was in his name. He wanted everything to be in his name. In the eyes of the court, in the eyes of the client, he was their lawyer. And in the eyes of the court and in the eyes of the client, he failed to adequately represent these clients and violated the rules, which justifies the recommendation of disbarment.
Thank you, counsel.
Thank you.
Thank you, counsel, to both sides. We will get you a decision within the time that it requires us to get it done. So, thank you very much. We're going to.
He said that funny. Yeah, he did get that done. Let me show you. Where are you? This one? No. This one? No. This one? Yes. So this was about less than 3 months later. You'll see here there are actually six disciplinary cases against him. This is a 56-page opinion. Just to skip to the bottom line, literally all of them agreed that he should be disbarred. Right before Christmas, just to rub a little salt in the wound. These six matters, I'm not going to read the whole thing, I'm just going to read the first paragraph. These six matters are before the court on the report and recommendation of the State Disciplinary Review Board, which reviewed Special Master Lavonda Rochelle DeWitt's report and recommendation. In each of these six matters, Christopher Casey Taylor, that's a very nice bar number, a member of the bar since 2002, is charged with violating several provisions of the Georgia Rules of Professional Conduct regarding clients of the law firm where he is a partner. Taylor's law practice and that of his firm has a heavy focus on immigration matters. Indeed, all 6 of these disciplinary matters arise out of representation in the context of immigration law. The special master recommended a 6 to 12-month suspension with a condition on reinstatement, while the review board instead recommended disbarment based largely on its conclusion that Taylor's lack of remorse should weigh heavily against him. Taylor initially denied that he was culpable for any misconduct regarding the grievance cases, but he now concedes the record supports a determination that he violated the rules concerning supervision of other attorneys, and he asks this court to impose a suspension consistent with the special master's recommendation of discipline. However, with the benefit of oral argument and having carefully reviewed the record, we conclude that disbarment is warranted. If there's interest, maybe I'll come back and read this whole thing, but I don't think I have 56 pages of reading me right now. Can you try to get into another state to practice? If he hasn't already been admitted to another state, it's unlikely he's going to get in. When you apply to practice another state, they check your bar record. Do a full background check usually. And this would come up, and I would assume this would preclude him from ever getting admitted in another state, unless he does a whole bunch of stuff like retaking a full bar exam, doing ethics stuff, probably waiting a few years. It would take a lot of effort to get admitted in another state. Georgia also doesn't take the universal bar exam. Yeah, I know, Aaron. Thanks for reminding me. Oh, God. I gotta show you guys something. I can't even get him to take a divorce case for low cost. I mean, he'll probably take it. It probably won't be low cost. And you'll probably end up being married to a second person by the end of his representation. You'll be double married. Look at these questions. Not these ones. I'd have to learn how to do this stuff again. After about 4 years ago, friends Celia and Victor decided to open a bookstore together in Savannah. Celia contributed $60,000 in cash, but she lives in Seattle and has never been involved in running the business. Victor operates the store and makes all the management decisions. For the first year, Victor performed these duties without taking a salary, and he and Celia agreed his sweat equity during that year would constitute his capital investment. After the first year, Victor began to receive a salary of $40,000 per year. Other than Victor's salary and the rent payments described below, no amounts have been paid or distributed to either Celia or Victor. I don't care about Celia or Victor. Celia or Victor? Celia or Victor? I want to do criminal stuff. I don't want to learn about Celia and Victor and capital contributions again. I knew this stuff once. I don't want to do this again. Just let me be a lawyer, Georgia. Please. What kind of business entity has been created by Celia and Victor? A limited partnership, a limited liability company, a general partnership, a corporation, or something else? It's clearly a general partnership. How likely is it that Victor has the right to unilaterally dissolve the business relationship with Celia? If he does have the right to dissolve, what does he need to do to effectuate the dissolution? You can always study on stream so you can grift at the same time. That'd be funny, actually. On January 10th, 2023, Perry Smith went to see his podiatrist, Dr. Botchett, and that's kind of funny, for treatment of a painful ingrown baby toenail. I don't want to learn about ingrown baby toenails or regular baby toenails. I don't care if Perry Smith has a painful toenail. I got people in prison I got to get out. I don't want to learn about toenails. Dr. B is a resident of Fulton County. The medical services at issue occurred in Fulton County. Perry is in DeKalb County. Oh, it's going to be a venue question, isn't it? Where will you file a complaint? Exactly. Counties of Georgia. Name all 159 counties. All right, question number 3. Alice and Bob met in 2000. That's a family law question? I have to learn family law again? I only studied family law on the way to the bar exam in California. That's the only time I spent learning family law. And I actually learned like the one topic I needed to know. Right after the ball guy said pattern and practice consistent with... Oh, really? I'm going to have to go back and listen to that. Identify all the streets with peach in the name. Peachtree, Peachtree Lane, Peachtree Street, Peach Lane Tree, Peach Street Lane, Peachtree, Peach Tree Tree Street. Oh, then this is... See, I'm not worried about this. This is the I don't know what they call it, the practice thingy. The competency exam, I guess. They like want you to show that you're actually a lawyer and know how to do stuff. They give you a bunch of stuff and tell you to write something like a lawyer would. I feel like I should just be able to like show them something that I've actually written in the real world, and then like the opinion that says I was right, and then that should be enough to get me in. Like, I don't have like hypothetical stuff. I have like real stuff I've written. Just let me in. Just kick out certain people that I'm not going to name and give me their license. Oh my goodness. Just send them a link to my channel. That's what I'm not going to do. I'm going to have to private my channel right around the time they're looking into me. I've said some things that some powerful people might disagree with. Okay. I get to call it a day because I get to do some work. I think I'm going to record a video later today, another Moonsoon video. That's funny. Lawnerd Amber just retweeted me. He said, y'all, come join and listen to this fucking pathetic excuse for why an immigration attorney figures his performance did not warrant being disbarred. So it'll piss you off. Spoiler, he was disbarred. That's true. You can rename to Supreme Court of Georgia fan club. I am a fan of their 8 out of these 9 attorneys. I'm not going to tell you which one I don't like, although I've explicitly said it more than once in the past. Ooh, I'll show you next up. Let's see. You can't see what I have these called. Winchester sicko mode? No. Mr. Ashley Merchant, looking right here. We're going to get back to this one soon, I think. The second best lawyer from Maine right there. But, okay. Those are some of our most vulnerable community members. Oh, definitely. Definitely. They're definitely most vulnerable. And also, like, if they lose the case, they're, presumably they're going to get deported. And it's not like they can, their recourse is just practically limited because they're in a different country. So, like, you can get away with so much, I would assume. Look, he is what he is. What do you want me to say? Oh, man. So, yeah, I'm going to do a Mooktoon video. I think I'm going to start breaking these streams into videos themselves. So, like, I'll break this into 3 videos for each of the 1 oral arguments. So people can go back and watch those individually if they want to. I should have been doing that this whole time. But I'm lazy. I'm fundamentally a lazy person. Like, I'm actually a very, very deeply lazy person. I'm just also very petty. And that makes me work hard sometimes, unfortunately. Okay, I think I'm gonna call it a day. I'm gonna do that. And yeah, hey Kat, are you streaming tomorrow? I assume Kat's streaming tomorrow because I think. Wait, tomorrow's no. Tomorrow's Sunday. Monday's the start of the thing, right? You're streaming tomorrow too? Okay. Yeah, I'll still live stream. I'll just put them on like not live too. Tomorrow's okay. Yeah, it seems like Kat and what's his face? The guy with the cool name of the podcast, Trial and Error, I think. They've really been driving a lot of attention to this case. And also, you know the best thing about the Holly Bobo case? What really like warms my heart is how mad it makes Nancy Grace. She's so mad. And there's nothing there's not like if I had to choose between myself being happy or Nancy Grace being unhappy, I would rather both of us be unhappy than myself be happy. Love and grace. What can you say? If we get a prosecutor named like Mercy, we got to watch out. Yeah, Kat and I watched, I don't know if anyone else was there, but it was on Discord. We watched an episode of Nancy Grace talking about the Holly Bobo case. It was fun. She was so mad. Delightful. All right. Okay, I'm going to go offline now. I'll see you guys. I'll probably come to cast stream tomorrow. I'll post a video later, or maybe early tomorrow. We'll see. But yeah, thanks for watching. I'll be back soon, I hope. I never know how to say goodbye, so I'm just gonna head out now.